May it please your lordship. May I have lordship's kind indulgence to move this urgent IA on Wednesday, my lord. Matter relates to my lord the cancellation of my selection to the Mizoram Grade 1 service, my lord, judicial service. And the advertisement has been issued and the last date is on 17th, my lord. That's next Monday. We have filed the IA on 6th, my lord.
But I think you are required to make this mention before the okay.
Deeply obliged, lordship.
May I please, your lordship. Lordship, with regard to item number 25, we have filed an additional affidavit, my lord. That may be kindly called for. Deeply.
May I please, your lordship, my lord? My lord, I filed one IA, my lord, for restoration of a writ petition, my lord. Although I submitted, my lord, Wakalatnama, but my name was not reflected in the cause list, my lord, for which that case was dismissed, my lord. Lordship will kindly take up this matter on Wednesday, my lord. I filed on, my lord, 6th of, my lord, last Friday, my lord.
Okay.
Deeply obliged.
May I please, your lordship. I beg to mention item number 18 and 19, lordship. Matter will be adjourned for 1 week, lordship. Engage counsel out of station, lordship.
Okay. In 92 after 2 weeks.
Much obliged.
May I please, your lordship. I beg to mention item number 1 for adjournment, lordship.
Item number 1.
Yes.
Okay. When do you want?
Repeat, lordship.
Okay. Password for the day.
May it please your lordships. Your lordships, I beg to mention for listing of a pending writ petition, lordship. Your lordship, the matter pertains to custodial date of the petitioner suspend. Lordship. Your lordship, I'm seeking
matter is about?
Custodial date of the petitioner suspend.
Okay.
Any date, lordship, before the
Let the courtmaster take a call. Give it to the courtmaster.
highly obliged, lordship.
Your Lordship, with the consent of the other side, I beg to mention item number 16, Lordship.
16. Okay. Adjournment slip was given. Okay. Both. With consent of the other side, the counsel of the petitioner prays for adjournment where is allowed. List after
Immediate, Lordship.
2 weeks.
Obliged, Lordship.
Item 2 for motion.
I please, your lordship. Well, because of an expertise proceeding.
Yes.
My lord, this is an expertise proceeding, my lord. I have challenged, my lord. This order was passed on, my lord, 30/12/2022, page 34, my lord.
At page
Annexure 8, my lord, page 34.
page number
34, my lord.
34.
Yes, my lord.
2018.
2018, my lord.
You have to wait for some time till the records are available.
My lord.
Because this paragraph 2 says that you left the place.
My lord, I was a daily wage earner, my lord. I am a resident of Morigaon, my lord. I went there for in search of, my lord, work, my lord. And the petitioner there, my lord, he worked for several months, my lord, and he came back. He did not come to know, my lord. Later, my lord, he could get the certified copy on 29th of October, my lord, 2024, my lord.
It's a fine. Page 32. I think this has to be set aside. There's no point calling for the records and then.
So,
If he's not a resident, then it should have been returned to the tribunal. The person is mentioned in the notice is not a resident of my village.
Yes. This can be remanded even though, otherwise also my lord, it should be hanged on the last residence of the person. But it was hanged in the office of the government settlement.
That's the reason.
Yes.
Yes. So the government to conspicuous place. It's not a conspicuous place. Yes. Right.
Yeah, the difference.
Yes.
But Mr. Hamad,
My,
this is a case of de-voter, is it not?
yes.
So therefore, if your name is there in the voter list of this particular village,
Yes.
then it will show something more that where were you resident? These things are not there.
But I could only annex the voter list only, the extract copies only. I had no time, actually. I'm very sorry for that. To prove my citizenship before the concerned tribunal. Now she will kindly remand the matter.
No, you see this, what do you call this voter list you are producing of 2005, we don't know of what was that status. But please come to this report of the inquiry officer.
Yes, ma'am. It says I'm a resident of Kolmovari under Mikirpheta police station in Morigaon.
This is not a devoter case, my lord.
This is not a devoter case.
Not a devoter case. It's a police reference.
Not a devoter case. Okay. Heard Mr. Zaid Ahmad, learned counsel for the petitioner. The respondents there. Mr. Kalita on behalf of Ms. P. Barwa. That's by filing this writ petition under Article 226 of the Constitution of India. The petitioner has assailed the ex parte opinion dated 12/2/2018, passed by the London member, Foreigners Tribunal Jorat, in so page 34, declaring the petitioner to be a foreigner post 24/3/1971 stream. Next paragraph. The learned counsel for the petitioner projects that the petitioner is a daily wage earner worker and is a resident of village Kolmo Bari, KOLMOUBARI, PS Mikir Bhita, MIKIRBHETA, in the district of Morigao. And in search of work, he had gone to village Gandhi Koiri, GANDHI, next word KOIRI, under Sarupatar police station at Golaghat district, and thereafter returned back. Stop. Next part. Accordingly, it is submitted that as the petitioner does not have a residence at the concerned village of Gandhi Koiri, the process issued by the learned tribunal could not be served, and therefore the same was hanged in the office of the Gaon Panchayat. Stop. Next part. Accordingly, the learned counsel for the petitioner submit that there are good and sufficient grounds for the petitioner to not appear before the learned tribunal to contest the proceedings. And accordingly, he has prayed for setting aside the ex parte opinion with a further prayer to transfer the proceedings to the appropriate tribunal at Morigao. Next paragraph. Although the learned standing counsel for the FT matters has opposed the prayer, but it is seen that as per the process service report, the government Kampura of village number 1, Kondha Koroi. It is not Gandhi Koroi. GONDHAKOROI. Under PS Sarupathar in the district of Golaghat, had informed the process server that the person mentioned in the notice is not a resident of his village, and therefore the notice addressed to the petitioner was hanged in the office of the Gaon Panchayat. Stop. This is not in accordance with the procedure prescribed under the foreigners tribunals within bracket. Tribunals is within bracket. Order 1964, which requires under Rule 2(5) F, within bracket F of the said order. Next paragraph. Accordingly, as the process was not served in accordance with law, the court is inclined to accept that the petitioner had good and sufficient reasons for not appearing before the tribunal when the matter was taken up for hearing. Next paragraph. Under the circumstances, the court finds no reason to issue a notice or call for the records. First of all, accordingly, the said ex parte opinion, page 34, is set aside. And the matter is remanded to this learned foreigners tribunal, Jorat, for a fresh decision in accordance with law after providing opportunity to the petitioner to file his written statement as well as evidence. Next para. As the petitioner is duly represented by his learned counsel, the petitioner is directed to appear before the said learned tribunal within a period of 21 days from the date of this order, and to present before the said learned tribunal his written statement of defense and any other document on which he intends to rely upon. Next para. Insofar as the prayer for transfer of the proceedings to Morigaon is concerned, in view of the judgment and order dated. What is the order that division bench order?
My lord, it's full bench order, no?
Full
Full
bench
bench order.
order dated so and so.
My lord, order dated
Pass.
25/4/2024. 25/4/2024 in batch of writ petition leading writ petition is WPC 1296 of 2022. my lord.
And name of the parties, do you have it?
Yes.
Just the name of the parties.
Makibur Rahman. MAKIBUR Makibur Rahman. RAHMN.
Versus the Union of India and others. The next, according to the petition stands partly allowed to the extent as indicated above. The parties are left to bear their own cost. The petition stands partly allowed to the extent indicated above, without issuance of notice to the respondents.
Only, my lord, an observation, my lord, if he doesn't appear, my lord, within this time.
Oh,
we are to-
She will appear, I can assure that.
in the event the petitioner does not enter appearance within the time allowed, it will be up to the said learned tribunal to treat the petitioner as absent on call and pass appropriate orders in accordance with law.
My lord. Deeply. Thank you.
Item 3 for motion.
Contested case, my lord, impugned order, page 28, order dated 12/7/2022, my lord.
22, then you'll have to wait for bail.
My lord.
Page number
28.
8. But this is a case, I think, within the motion stage, we'll have to dismiss it. This is a case where you have to dismiss your writ petition at the motion stage.
Lord.
You come to page 28. The first thing we noticed is that the certified copy was obtained then. So it is a negligence on part of the petitioner.
Lord, LCR may be called from hard on merit, my lord. And only prayer, my lord. LCR may be called for. Otherwise, it's a good case on merit, my lord.
Delay defeats equity.
My lord.
Presence had the present situation not come, my lord.
Vigilante bus, non dura. What is that? What is that? Vigilante bus, non dura.
Dura subvenient.
Huh?
Dura subvenient.
Thank you. Mr. A.W. Aman, I'm counsel of the petitioner. All the respondents are there. Opinion is at page 28. dated 12/7/2022, passed by so and so and so and so. The police reference D case number so and so. Thereby holding the petitioner to be a foreigner post 25/3/1971 stream. Notice extra copies within 2 days. Call for the records. The prayer for bill shall be considered on receipt of records. List, give a fixed date after
My
4
lord,
weeks.
maintainability may be kept open.
Okay.
Let it.
Before that, issue notice, you say keeping the issue of maintainability open, issue notice.
Grateful.
Just a moment, we give a date, fixed date,
18th of July.
18 July.
Item 4.
Yes.
In this case, my lord, we are challenging the impugned service rule, my lord. Assam Element Edition Provincialization Rules 1977 as amended in 2024.
On what ground?
Mainly on the ground that, my lord, it is not in conformity with the Central RT Act 2009 and followed by the, my lord, RT Rules 2011. RT.
Why do you say so?
Because, my lord, the RT Act as well as the RT Rules 2011 has mandated that the state should grant equal scale of pay and all benefits to the teachers who will be recruited after the enforcement of the RT Rules 2011. What happened? The state has, my lord, done the appointmental exercise, my lord, through the SSA Assam and appointed the LP-UP TET teachers on contractual basis. That itself is an irregular exercise, my lord, on the part of the state. That could not be, because in a provincialized school, a society has no authority to appoint, my lord. It is the government which has to be, which is the competent authority to appoint, my lord. And, my lord, they have not done that, and without doing that, my lord, they have recruited the teachers on contractual basis.
But then your reputation would not be maintainable. Even in symbolic manner, you are not implicated the persons who will be affected by orders, if any, being passed.
My lord, we are not against any private individual, my lord.
So what would happen if we, supposing we strike it down today, then what happens?
My lord, we are not actually for striking down. We are, my lord, praying for, my lord, modification of the impugned rule, my lord, so that, my lord, the retrospective benefits of regulation could have been granted as following the, my lord, the
But
benefits of the RT
Can
Act.
the court direct, can the court direct the state to to make amendment in the rules? Is it within our domain?
Yes, because, my lord, it is, my lord, not as per the central rules and acts and, my lord, rules, my lord. And in this regard, my lord, the number of cases are pending in the single bench, my lord, as because this was with regard to the issue of, my lord, advertisement and etc., my lord, and therefore only the rules is put to challenge here, because the all the other issues arose, my lord, out of the advertisement etc., my lord, for regulation of employees, my lord.
Please tell us, are you the beneficiary of appointment under this notification of 11/7/2024?
Presently, we are serving on contractual basis. We did not opt for the regulation because this is the.
No, we are not asking that question. The question is that, have you been appointed under this 11/7/2024 rules?
I have not been appointed under this rules, my lord. We have been appointed on contractual basis, my lord. And those who have been appointed on contractual basis for regulation of their services, this impugned to service rule has been incorporated, my lord, amended, my lord. And that, my lord, we are agreed mainly because the past service benefit, whichever we have got, my lord, would be nullified. And therefore, we have not opted for, my lord.
You have not been provincialized or you have not been regularized. You have not been brought to the normal cadre. You are still continuing as a stateful teacher. In
Not
the
stateful, well, contractual.
contractual basis. How is this rule affecting you?
My lord, this rule is affecting because our aspiration is to become the regular
You have
teacher.
not opted to for that.
How can we have to opt, my lord? This is a condition precedent, my lord.
That exercise, that one-time exercise that they have
This is not
taken.
one-time exercise. This is not one-time exercise. This is a planning process is going on, my lord. It's
Once
not
the
one-time
options you have been given, you have not accepted. How can you go back to that stage?
Now we.
Mr. Mazumdar, what is your take on
There
this?
is another petition pending on this issue, whether the contractual teachers would appear in the examination that we held, by which we would bring them into the state services. Most of the teachers have appeared in the examinations and they have come into regular service now.
They have no grievance.
They have no grievance.
Mm.
This, my lord, I do not know, once they do not take that option, can they come and challenge something which they are not, when they didn't opt to come into the service at all?
Because by nature, the reference here is a special recruitment drive.
Yes, we did that. We held the examination.
That itself is illegal, my lord, because the government or central government has repeatedly mandated them, my lord, not to go for dual cadre system. And they have gone for dual cadre system.
Dual cadre system is with regard to pay. It does not say that you will also have to be regularized, given pension, everything. That rule, that central government notification, no way mandates that. You have drawn an analogy. Fine.
Rule 18, my lord, of the 2011 RT rules, my lord. It clearly says, my lord, the same, my lord, has to be granted. Same benefit has to be granted.
Where is that?
Rule 18, my lord.
Right to education. Right to education. Right to free education.
241 starts, my lord.
$241 of
41 of this education manual, my lord, it starts. I'm coming.
education.
Salary and allowances and conditions of service, page number 265. This rule has come into effect on 3rd of November 2011.
Rule?
Rule 18, my lord, page on 265.
Sorry, we can't bring you under this.
Because, my lord, we have been, my lord, appointed on contractual basis.
Your prayer for regular pay, as that is being got Jagjit Singh, whatever you say, that's one aspect of the matter. But here is considering you as a regular incumbent in the cadre. You were given an option. You did not opt for it. Persons have opted, they have come in, they have no grievance. Now, at your instance, why should we now come in and set aside that rule or read down that rule?
My lord, because those persons who have been my lord, brought
They are
on-
not before us. Even you have not made them parties.
we are not against them, my lord. They have opted, they have, it is their desire and pleasure, my lord. But our question is that, my lord, once under this rule, we have been opted, we go for the regularization, my lord, then we would be deprived of our past service benefit, which, my lord.
That is an additional thing. If you come into the cadre, then you have a grievance that please consider past services also. we would have understood. But you have not done, opted for that.
Once we opt for that, my lord, it's a condition, my lord, we shall go for that agreement, my lord.
You can still, there is no bar, you can still challenge that. But now you have opted not even to come into that service, remain as a contractual.
No. We have, my lord, challenged to become the regular with effect from date of regular appointment, my lord. Not from this date of my effect from the of this
Mr. Professor, we
2024
come back
rules,
to
my
the
lord.
first question we asked you. You see, unless you convince us appropriately, what we understand is that if we set aside the regular that rule, it'll affect. It'll be as if the rule did not exist, and therefore the appointments made can't be saved.
And let it come on that I will take instruction. I will go to it for.
Otherwise, we'll have to prospectively say that this rule will be interfered with prospectively. Then also you're out. If today we read down that or set aside, still you can't come in. It will be prospective. So you'll have to, if the government gives you a second option, then only you may be there, or prospectively the government will make a new rule. So it will be a writ in futility. If it's a writ in futility, we will not still interfere or issue notice.
Has it come after warning, my lord?
Because we are not advising, but we think that you should withdraw it and then make a challenge comprehensively. We are not suggesting you anything. We are just thinking aloud. You want an adjournment next week? Okay. In the next Monday? Oops, just, on the prayer made by Mr. B. Pulkasur and counsel for the petitioner, the matter stands adjourned today. Mr. R. Mazumdar, and standing counsel for the Education Department. Mr. I forgot the names. Mr. A. Alam. I Alam, done at standing counsel for the NCT, and Ms. P. Fukan, done at K. Fukan. Says, okay. Government advocate for step number 1, 2, and 3 are present. Okay.
Item 5.
No, sir. It's no, sir. It's not just only that. May I please solution? Improvement order is at page number 65, my lord. Election 65.
65.
Yes. Look, there is some delay, my lord, but lord, he is belonging to very poor family, my lord.
You have to tell us why we can't dismiss this repetition.
Mentioned it and paragraph number 32 at page number 29. my lord.
Paragraph number 32.
Page 29, my lord. In the summary, I may not have mentioned it. My lord.
This cannot be a ground. This can't be a good ground. You see, you appeared through a lawyer before the tribunal. In every district, we are spending so much of huge amount of money to put up a board to regularly put up kiosks for legal aid, free legal aid. The amount of expenditure we are making is enormous. For the district legal aid council, we are paying a huge amount every district. Even in this court, we have a lot of cases filed, at least every day. 7 to 8 cases we are permitting the legal aid to be given. So this can't be a ground. You are referring to page 65. It's an opinion of 5/11/18. Now we are in 25. And then please come to page 67. Oh, sorry, same page 65.
He has obtained the copy, my lord.
Copy is obtained on 24/5/19.
Yes, my lord. Thereafter, my lord, he failed to, my lord, access the server, my lord. Not providing, my lord. My lord, sir, matter may kindly be hired on merit, my lord, after receiving LCR, my lord. But otherwise, my lord, the issue is involved in citizenship, my lord. If his citizenship goes, my lord, only due to delay, my lord. That's, my lord. Whole family will suffer, my lord. Not only that, the petitioner cannot, my lord. That is-
In this petition, which is the best document you have to connect you to your projected parents?
Well, and in the copy of NRC, my father's name is reflected. My lord.
NRC is not an admissible evidence.
My lord. But my lord, after that, prior to 1966, my lord, my father has died. My lord. And my lord, I next one document, my lord, of 1968, wherein my name is reflected, my lord. That is at page number, my lord, 19, my lord. Relevant portion I have mentioned, my lord.
There is a
After-
copy of Exhibit 7. This land document you're referring to, is it at page 54?
My lord, there is one problem, my lord. The Kirasi Patta, which has been, my lord, exhibited, he has later on he has, my lord, filed petition for my lord, providing certified copy of the annexes, my lord, annexes and exhibits, but those are not
Certified copy of?
annexes and exhibits, my lord, submitted before the learned tribunal, my lord. But those documents are not provided to him, my lord, and he could not say exactly which document he produced, my lord, because he is an illiterate person. Only he can put his signature, my lord. That much enough, my lord. He cannot, my lord, read the contents of the document, my lord. Therefore, some problem is there, my lord. Whether I cannot exactly say, my lord, but he shows me that this document was produced, my lord. That's another problem, my lord. And, my lord, kindly, may I pray your lordship to kindly come to page number, my lord, 87, my lord. This document was, my lord, produced before the learned tribunal along with his WS, my lord. And later on, in the year of 2011, my lord, the next annexer, my lord, that is annexer number 18, his name has been, my lord, mutated as legal heir, my lord. This document was produced before the learned tribunal along with the WS, my lord.
But from your submission, it appears that the petitioner is a wealthy person.
My lord,
You produce a copy of land documents at page 54, and then you say, I don't know which document I produced before the tribunal. That means that you have many plots of land, and therefore you don't know which you produced, which you did not produce.
He has some plot of lands, my lord, but those lands are submerged underwater of, my lord, river Brahmaputra, my lord. My lord, this
Then,
is the fact, my lord.
then you have to say sorry to your client. Come to page 36.
Yes, my lord.
See paragraph 10, dark number 752.
Yes, my lord.
Come to page 55. Dark number is 752. So it's the same document you are producing.
Yes, my lord.
But you did not satisfy yourself whether it's a correct document or not.
Not my lord, this law, this one is correct, my lord, but in evidence, my lord. I am referring to the evidence, my lord. Evidence, my lord. That is at page number 39, my lord, paragraph number 12, my lord. This document, my lord, there is no such indication which, my lord, dark number and pattern number the land belongs to. Therefore, this problem arises, my lord. Page number 39, my lord, paragraph number 12, my lord. So, that is the problem, my lord.
So,
My lord, and the earlier document lordship has referred to, my lord, that is near the pattern number 290, my lord. I have annexed this document at page number, my lord, 87, my lord. That land has been mutated in the name of the petitioner, right annexer 18, my lord, in the year of 2011, my lord. And his father, since his father died in the prior to 1966, my lord, the land also belongs to that period, my lord, prior to 1966, my lord. And that the land has been mutated in the name of the petitioner, my lord, as legal heir, my lord. And my lord, in answer 19, my lord, here the deed was executed in the year of 1968, my lord, by the mother of the petitioner, my lord, while the petitioner and his brother was minor, my lord, and their name has also been recorded in that document, my lord. That shows that the petitioner was existing at that time, my lord, during 1968, my lord. And in that document itself, my lord, it is mentioned that his father was died, my lord, at that time. That means the version of the petitioner is correct, my lord. From that document also, my lord, it is clear, my lord.
in your written statement, who is Monser Ali Mullah?
Munsir Ali, my lord, my father, my lord. My lord, petitioner also has examined his, my lord, cousin brother, my lord, whose name is recorded along with the name of the father of the petitioner.
Then your story doesn't match.
My lord,
You see, you say that when did your father die?
prior to 66, my lord.
Prior to 66.
Yes, my lord.
Then how can he have a patta at page 89 issued from
Yes.
31/3/2009?
Yes, my lord. I also have that question, my lord, but the record has been maintained as earlier, my lord. My lord,
It can't happen. It can never happen.
My lord, This is happening, my lord. That is the pattern, my lord. And
It can never happen.
my lord, that may be, my lord, but it is, my lord, issued like that, my lord. By inserting the earlier name, my lord, that is issued, my lord. Until the application is met, my lord, for mutation, my lord. This is happening, my lord. My lord, oh, one more. So one more thing is that, my lord, the petitioner was not cross-examined by the, my lord, state.
Not required. You prove your case. Now let me ask you. In your career, have you got information about any suit being decreed ex parte? Has it never occurred to you? Suit can be decreed ex parte, and can a suit be dismissed ex parte? Then why is a cross-examination required? You make out a story and you don't. The story is not found acceptable. You see, this is a reference of 2003 by the IMDT. References of 2003. After 2003, that means when this inquiry was made, you are aware of the proceedings against you. After that, we are only seen one document which you have shown.
Well,
Your father, you say, is died in 1966. Now, therefore, this patta, you get it in 2009 in the name of your dead father. And then next page is page 91. Now you get this mutation done on 2/5/2011.
Yes.
So how can a patta be issued against a dead person?
My lord, may I pray,
And you're not connecting this with any document.
my lord, may I pray your lordship to kindly come to the page number 93, my lord.
Page number 93.
Yes, my lord. That is the, my lord, sale deed, my lord, executed by the petitioner and mother of the petitioner and his brother, my lord. They were minor at that time, my lord, 1968, my lord.
Yes.
That is, my lord, that shows that he is, my lord, available in this country prior to 1971, my lord.
Unfortunately, the mother is someone you are not introduced in your written statement as page 35.
That is the problem, my lord. My lord,
Then come to page 41, it's your affidavit. In our
yes,
affidavit also,
this type of,
I don't find your mother being introduced.
But document is there, my lord. My lord, that is the, my lord, fault in pleading, my lord. And at that time, my lord, in maximum WSS, my lord. WSS was drafted like that, my lord.
Oh, no, no, you please don't say that because you have not accused your lawyer of
My lord,
either professional misconduct or professional in what do you call his unprofessional attitude. That's not your case.
Sorry, my lord.
You don't question your when in writing you don't question your lawyer. You please don't make submissions against our lawyer.
Well, I have to, my lord, examine my brother, my lord.
Okay. Heard Mr. M.H. Talakdar and counsel for the petitioner. All the respondents are there. Opinion dated 5/11/2018, page 65. By so and so. In case number so and so, reference case number so and so. Declaring the petitioner to be a foreigner of post 25/3/1971 stream. Notice returnable on 18/7/25. Extra copies within 2 days. Call for the records. The prayer for bail shall be considered on receipt of records. List on so and so.
Maintainability may get to the law.
Okay, just before that, before issuing notice, you say keeping the issue of maintainability open, comma, issue notice.
Well, in the meantime, he may not be deported. my
No,
lord.
no.
Well, honest.
Item 6.
Merci, Your Lordship. Milord, this lady, Milord, was picked up on 24/4, Milord, 2025. From her residence, Milord. Opinion is, of course, on 3, Milord, page 31 and then 17. Milord, she approached this honorable court also earlier, Milord. The next party order was, Milord, she was given an opportunity. But that also, Milord, our version is that she received it late, Milord. Their version is she received late, Milord. And the date was missed. Yeah, Milord, she was in a detention camp for 2 years, Milord, and released, Milord. Page 28, Milord, is the bail bond, Milord.
Where's the last order we passed? I don't have a copy.
Well.
Where's that?
It may be in item number 29, madam. 29, 30, 31. I'll list.
Yes, Lord.
It's possible. WPC. WPC.
When was the petitioner apprehended?
Milord, 24/5/2025, Milord, at 4 p.m. Milord.
Can I mark it?
Milord.
What is the name of the proceedee who has been arrested?
Doyjan Bibi, Milord.
How do you spell it?
DOYJAN.
TOI.
DOY, Milord. DOY.
BOI.
Doyja.
Because in the cost title, it is not there. That's why we have to find it.
Milord,
DOY.
I mean, it's
Yeah.
written in the synopsis, Milord. Sorry.
Page 29, my lord, order is there,
Uh,
early order.
His wife of?
Wife of my lord, Milord, the petitioner Abdul Razak, Milord, who is before your lordship, Milord's petition. Abdul Razak, REZZAK.
He was arrested when?
24/5/2025. From Madhu Salmari Park to village, Milord. Hubli.
From?
Madhu Salmari, MADHU.
Where do I get that?
Milord, the synopsis, Milord, there. Page, first page, Milord.
This village in which district? Dhubri.
Dhubri, Milord. Under Gauripur Police Station, Milord.
And where is the, what is the date of opinion?
Milord, 31/8/2017, Milord. It could not be annexed, Milord, it was misplaced, Milord.
31/8/2017.
31/8/2017, Milord.
You have the reference number? No.
The reference were FT, Milord, FT 4/71 stroke GPR of
No, that is the case
case
number.
number, Milord. Case number. Reference number is not there, Milord.
Reference number is not there.
Not there, Milord. Case number is there.
It is easier for the police to track
Yes,
that
I
record.
understand. Not there, Milord. Milord, yes, they are there, Milord. Page 28, Milord, in the bail bond, Milord. Reference C number
28.
8, Milord.
Just a moment.
Milord.
C number. What was the date of detention? Please say again.
Milord, 24/5/2025, Milord.
Earlier, she was arrested when?
Yes, he was arrested, Milord, in March 2019. A specific date could not be, Milord. He could not say the specific date, Milord. But it was released on 28, she was released on 28/5/2021 after 2 years, my lord.
She was released on
My lord, 28/5/2021, my lord.
released on
20
what is the date?
28/5/2021.
Uh, zero page. Or in order to be revived. Just take paragraph 5. Take paragraph 5. It from the materials available on record, comma, it appears that the ex parte opinion dated 31/8/2017 passed by the learned Foreigners Tribunal number 4 Dhubri in FT 4/71/GPR/2017 was set aside by the coordinate bench of this court by an order dated 24/9/2021 passed in WPC 2028/2021, full stop, however, comma, on condition that the petitioner, the wife of the petitioner shall appear before the concerned tribunal on or before 27/10/2021, failing which the impugn opinion would be revived and law will take its own course. And the bail order would also stand cancelled. Full stop. In paragraph 14 of the writ petition, it has been admitted that the wife of the petitioner did not appear before the said learned tribunal. Stop. Under such circumstances, no, take it. Rest will be here.
The writ petition number maybe 2028/2020, not 21.
Which one?
Writ petition number is 2028/2020, not 21.
Okay, 2020. Okay. No, because it's in this,
Order is of 21, but
Order is 20.
this writ petition is
Para 14, 2028/2020.
Petitions 2020. We take it up next week.
Yes.
It'll be 16th of June. Correct the order.
Obliged.
Item 7.
May preserve.
Yes.
So I'm agreed by order dated 19/3/2025 at page 80, Lordship.
80.
80.
Yes.
May I read the order? The proceeding is absent, cause shown by learned counsel. Learned counsel has filed a petition bearing number so and so seeking to prove the authenticity and genuineness of Exhibit F affidavit. File along with additional affidavit, evidence on affidavit. Heard learned counsel for both the sides, peruse the case record, particularly Exhibit F affidavit. It is seen that the said affidavit was sworn by the father of the proceeding before the executive magistrate Guwahati in the year 1985. That the affidavit was sworn more than 40 years back, and the record of the register of the executed affidavit in my view was not maintained at that period, and hence my prayer was rejected. What's it?
Correct.
And I am agreed by that order because by that affidavit, my father has changed his surname from Mal to Mandal. That is the only document to show the linkage with my father regarding the title surname.
No, but you see, let us say that we for the time being, you presume that we are taking up this affidavit and we are examining it as an evidence. Now, how would we draw our inference that who is the person whose signature is whose thumb impression is at page 78 and 79?
That can be proved by the advocate who has identified it and by the executive magistrate before the affidavit was sworn.
No, because it's a thumb impression. Nobody can come and say that I remember this thumb impression. Thumb impression is something which only a forensic can give an opinion. A person would not know whether this is his thumb impression.
And that can be one Lordship. By forensic also I can prove that.
But
otherwise, I have no other document to prove linkage with my father.
no, but you see, what we understand of what little we understand of evidence is that the thumb impression of a similar age has to be sent to the forensic examination to say which is an admitted, it will be compared with the original thumb impression in one of the documents. Now, if you say you don't have any document, how will a thumb impression of a person of 40 years ago will be examined?
I got the original also with me.
But that original thumb impression, the thumb is not there. So therefore, we'll have to, therefore, we'll have to examine this record with some document of same period.
Tail deed was also there. That is of 1958.
Where is the sale deed? In this sale deed, your father was the executant.
Yes, yes,
He executed it.
yes. At page 28, that is the type copy.
28.
Yes, sir. Then page 30 is the vernacular.
No, 28 is the purchaser.
Yes, Sombu Suran Mal, that is the my father's name.
So Likitong, that is the seller. Seller is Mahendra Chandra Rai.
Buyer is Sombu Suran.
Because at that point of time, this the purchaser did not have to put this signature or thumb impression on the document. So the sale deed will only contain the name of the signature of the seller.
Seller.
This also doesn't prove. You see, you are showing us page 28.
Yes. But it's
There is some document at page 27. Correct.
Yes.
Now, you see, if this was a zamindari estate, zamindari estates were abolished by the 1951 Act. So this document is of 1964.
It seems.
So when the zamindari was abolished in the year 1951, how can this be a valid receipt issued by a zamindar in 27/8/1964?
That I don't know, but they have issued it.
No, that's why we are asking you that question. Number one, that's one, for example. Second is page 28 you are showing is a sale deed of
58. 58.
58, 11/6/1958. So this land must have been devolved on you after the death of your predecessor. So where is that connectivity? Why you only need that affidavit to be proved? If you have a
In all other documents, my father's name has been shown as Sri Sombu Saran Mal. By that affidavit, he has changed his surname from Mal to Mandal. That is it.
by this affidavit, what he has done?
He has changed his surname. His title. That is page number 67. Para 2, that I have been known as Sombu Mal, and now I intend to change my title to Mandal in place of Mal. And 4, that all my successors in interest shall inherit the title Mandal in place of Mal by virtue of change of my title as government.
But this land, do you still have this land?
I'll have to enter.
Pardon me?
I will have to take instruction of that. But Lordship, in my,
Because if you have that land, then you can always show it otherwise.
on submission, Lordship, the 58 document was registered. There might be some, his thumb impression before the registry also, Lordship. It is a registered deed, Lordship. It is registered, Lordship.
Yes.
Before the sub-registered.
No, but there's a little chance that your thumb impression will be there because on prior to 2001, it was a unilateral document always.
In the registry also, it is not.
In the registry office also, there was a thumb impression only on the person of the who's there in the document. So another person's thumb impression will never come there.
Only seller.
Because even if your father sold this land, then he would be the seller and his thumb impression would be there in the sub-registry for selling that land. Because we are not satisfied that you will be able to, you'll have to tell us how you intend to prove this document. Once you give a satisfactory answer that yes, affidavit original which you have, a thumb impression
In some other.
put therein can be otherwise proved.
May I pick this matter on Friday, Lordship, I will take instruction.
Okay.
Thank
Because if you can show us that this is the manner in which you want to
Yes,
prove
sir.
it,
I'll try
then
On-
we will consider. On the prayer made by Mr. M. Mahathir and counsel for the petitioner, list on
Friday.
13/6/2025. All the respondents are present.
Correct.
Supply item 29 for motion.
Same order? No, my Lanet friends are asked to bring the instructions today, madam.
But they all are in Kufrajar holding center.
At Kokrajhar?
Yes.
Okay.
In that case, my lord, they will give the visitation right with the, my lord, like Lordship has passed in the other case, my lord, Toropali, my lord.
You have a copy of that?
Yes, my lord, I have, my lord.
You can sit down.
Take one. My lord, some. We triggered it in a button. Bakkar Ali, Sanaullah Sheikh. One, 4, 3. Can we print out the document? One person has been handed over, one person is. Here to. They took it. They took it. Here to be. 3143 in read petition number 3143, madam. Yes, madam. Samsul Ali,
Yes.
he has been handed over to my lord the BSF. As per the my lord direction of the BSF. On the basis of the Government of India notification, my lord. So he.
But that would be not enough. You'll have to, the central government will have to now tell us.
Yes, madam. My intention is that, madam,
This for Union of India, who's there? KK Parashar, give a scroll for KK Parashar, CGC. Okay, so for this item, we'll pass orders after some time. And for this, we give you liberty to for visitation right in other two items, 29, 30.
Yes.
But you are also required to file an affidavit.
Yes. We'll file affidavit.
In item 29 and 30, pass separate orders. But this time, Datar and counsel for the petitioner. All the respondents are there. By an order dated 4/6/2025, this court had directed the London Standing Counsel for the FT matters to obtain information as to the whereabouts of the father of the petitioner, namely, Abdul Sheikh, as to where he is presently lodged, if not already reported, and to provide information as to the place from which the and in the event the father of the petitioner is deported, to obtain information as to the place from where the father of the petitioner was deported and the manner of deportation. Next paragraph. Upon instructions, the London Standing Counsel for the FT matters is submitted that the father of the petitioner, namely Abdul Sheikh, ABDUL SHEIKH, is presently lodged in the holding center
Yes. At
under 7th AP Battalion at,
Saraikula, Kukurajar.
give that spelling again.
Saraikula, CACRAIKHOLA.
Sorry,
Saraikula, Kukurajar.
next paragraph. On such disclosure being made, the court is inclined to grant to the petitioner, namely Sanadul Sheikh, SANIDUL, Sanidul Sheikh, SHEIKH, to be Sanadul Sheikh and two other family, along with the maximum two other persons, visitation right to the detained person, namely Abdul Sheikh, at the holding center at 7th Assam Police Battalion, Saraikula, Kokrajhar, on a production of a certified copy of this order, the official who is in charge of the said holding center and having custody of Abdul Sheikh shall permit visitation right to the petitioner and two others full stop, the said authority shall also permit shall also allow the petitioner to obtain signature of the detained person in the wakalatnama, to be duly identified by the said official. Next, by the learned counsel for the petitioner shall inform if the visitation right has been allowed on the next date of listing. Next, by list on after 10 days.
Or 26, 20/6. Oblige lordship. Deployable.
Next item. Next item, the name of the detainee will change.
And his husband, madam, the husband of the
Husband,
petitioner.
what is the name of the husband?
Husband Majibur Rahman, madam.
Majibar
B.A.
Rahman,
Ram.
Rahman, alias Majibar, Majibar, Sheikh, Sheikh.
Wife's name is Rajia Khatun, ma'am, who is the petitioner.
Two people have been.
No, ma'am, one person.
Okay, the petitioner is Rezia, REJIYA,
Rejia Khatun,
Razia Khatun, KHATUN,
wife of the mother.
wife of the detained persons. Same order, same place?
Yeah.
Mr. Pang, same place?
Same place.
Okay. We'll take a short break and come.
Item 31.
Oh, yes, you have come. Here, the petitioner is given to the custody of BSF.
Lordship.
So we'll have to get information through BSF through you.
Lordship, I can get that in. But I will have to take the particulars from my friend.
Ah, yes. We'll provide in the order only.
Yes, Lordship.
Heard Mr. M. Dattal and counsel for the petitioner. Also, all the respondents are there. Mr. R.K.D. Chaudhary, learned DSGI for the Union of India. You'll get the slip of advocates. Next para. Pursuant to order dated 6/6/2025, the learned standing counsel for the FT matters has submitted that as per instructions received, the Samsul Ali, SAMSUL, Samsul Ali, the father of the petitioner, namely Bakar, BAKKAR Ali, has been handed over to the Border Security Force at
Mother, it said the border security force, madam.
no, but Mr. Chaudhary will not be able to locate like that. It has to be some post somewhere.
That exact instruction is not there, mother. It is stated.
Then we possibly can't grant, then we'll take it up tomorrow.
Yes.
You provide information by tomorrow. BSF stop. However, he does not have particulars of the BSF post where the said person has been handed over. Next para. According to the providing of incomplete information to the learned standing counsel for the FT matters by the border police is not at all appreciated. Full stop. The concerned officials of the border police, including the superintendent of police border, Chirang, should have been well advised to provide appropriate particulars to the particulars, instructions to the standing counsel for the FT matters in cases where, particularly in this case, where the father of the petitioner was he is stated to have been apprehended on 25/5/2025 without disclosure of his whereabouts. More so when he was handed over to the border security force. Next para, accordingly, the superintendent of police within bracket border, Chirang, command receipt of telephonic instructions, telephonic call from Mr. J. Pang, the standing counsel for the FT matters, shall inform the should provide information through WhatsApp as to the particular post of border security force where Samsul Ali, father of the petitioner Bakar Ali, has been handed over. And also provide a copy of memorandum, if any, of handing over. Full stop. The learned standing counsel for the FT matters shall share the information with the learned DSGI before the matters called up on the next date of listing. Next by list on tomorrow. It'll be 10/6/2025, 2015.
Oblige lordships. Declaration.
Just a moment. The learned standing counsel for the FT matters is permitted to transmit a download copy of this order by WhatsApp to the superintendent of police, Chirang, border Chirang.
Deployment.
Item 32.
Yes, the Advocate General is there. You have a.
Executive.
Okay. Yes.
May it please your lordship. My lord, agreed by the notice of 314 under the surface, my lord. But just in a tax, I'm putting the background, my lord. 64,12,253 was the loan amount. Thereafter, my lord, in the meantime.
You see, incidentally,
Yes.
while reading few of the judgments, we found out
Yes.
that if I am to do the calculation, then a rate would not lie. What is the due amount? What is the due? How much you have paid? What is the interest
Yeah.
calculating? If I have to do that calculation,
My lord,
then a rate petition would not be maintainable.
my lord, therefore, my lord, my lord may take it as a mercy petition, my lord. For that reason, my lord, that since my lord.
No, for mercy,
No, my lord, 13. I
For
just
mercy,
did-
there's, you see, we, in a lighter note, we say
Yes,
that for giving mercy, God has given you a forum of debt recovery tribunal.
I know that, my lord. Before that-
God's will has come through the legislature.
Yes, my lord.
And it is,
Just for the answer of justice, my lord. Only just one prayer, my lord, limited prayer. After 13-2 notice, my lord, I have deposited another amount of 35 lakhs. And thereafter, my lord, I sought time from the financial institution, my lord. Some time may be given so that, my lord, I will repay the same. That was my representation also, my lord. But immediately thereafter, 13-4 notice came. That is where I am agree, my lord. My lord, I am also ready to pay an amount within 6 months.
you have the latest,
Yes.
what is the latest judgment by the Supreme Court of India on the point of entertaining of the writ petition by high courts. You have the last order.
No, my lord. My lord, I am not aware of them. I'll have to go through. My lord, my instruction is that, my lord, within 60 days, he will be in a position to hand over 20 lakh rupees, my lord. Thereafter, because when, my lord, this 16-4 will is to be, then, my lord, a question of again auction would come, my lord, third party rights. My lord, 60 days,
Can't do anything. The hands
My-
are,
my client undertook to repay an amount of 20 lakhs within 60 days, my lord.
no, we appreciate that, but we can't do anything.
My lord, I have cited the reason, my lord. Since during the COVID breakdown, thereafter, my lord, the original institution was, my lord, merged with this particular autumn, my lord, respondent, my lord. So that information was also not with me. So unintentionally, my lord, installments were left to be paid. We only had information when we received 13-2, my lord, that it has been merged with another.
Except for 2 or 3 persons, I can notice from here, everybody is in requirement of some Mahajan who can give us loan without caring for installments to come back on time.
I understand that part.
Those 2 or 3% don't need a loan. So that's why, except for these 2 or 3 persons, perhaps everybody is in need of some money of some sort without the lender caring for timely repayment of installments.
At least with the unsecured loan, my lord, it is hardly repaid, my lord.
I'm sorry, Mr. Hazarika, we are dismissing your writ petition
My lord,
with
then.
liberty to approach the debt recovery tribunal.
Yes. My lord, then I may be allowed to withdraw and with a direction to file appropriate application before the DRT.
Yes, yes.
My lord, can there be an observation regarding that, no coercive motion till then, my lord?
Oh, we are so miserly.
At least that approaching the.
We are very miser people on that.
My lord, only we are apprehending, my lord, third party right would be created, that is.
Can't be helped. In 2023, Supreme Court says that the High Court should have a hands-off approach.
All right, ma'am.
Uh, Mr. Hazarika, since you are standing here as a learned counsel, I'm asking you, you want us to record that after some deliberations, you are withdrawing it so that it carries a different meaning, or you say that you are withdrawing it yourself?
I'm withdrawing it myself
Okay.
because otherwise it will be.
Okay, we are asking you just
Yes,
because you are
yes.
as a counsel, we
Yes.
don't want to embarrass you.
Yes.
Next para. Mr. T.H. Hazarika, then counsel for the petitioners, seeks liberty to withdraw this writ petition and to approach the jurisdictional debt recovery tribunal. First off, the prayer is allowed. The matter stands dismissed on withdrawal with liberty as prayed for.
Deeply obliged, my lord.
Item 8 for admission.
Okay, this is a writ appeal before taking the learned single judge's order. Matter relates to lordship, a mining lease of 10 years period. So lordship, the matter is in fact ready for hearing. In fact, on one occasion, it was heard at quite at length. So my prayer today will be lordship that as today is a miscellaneous day, it will take at least 3-4 hours. So on a hearing day, lordship may be pleased to fix this matter. Otherwise, everything will get upset today.
No, we appreciate what you have said, but these days, one of us in the bench is taking up this APSC matters for day-to-day hearing.
Lordship.
2 days, the what do you call that bench is not available. So it will be again starting from 12th. And so therefore, can we fix the matter at the end of June? That would be, you choose a date in the end of June.
If lordship is available on this
Oh,
Thursday.
sorry, last week of June will be before vacation. I think it goes after vacation.
Would it be on this for Thursday, lordship?
On
Thursday,
which day?
today it will be, no, it is 12th is the lordship's day-to-day hearing fixed.
We are fixing up day-to-day matters.
Next is not
Because
available.
we have a timeline.
Understand. I do not want to interfere in that, lordship. That, would it be on something like on 24th June?
But that is just last week before vacation. Hearing,
Or maybe.
even I think you
or
will be in
we
a
can
difficult.
take a chance on 19th June, Thursday. It will not spill over to the next day, lordship, if it is.
No. For you, it is
Yes.
one part, but for us to take up the matter and then
And understood.
hear it. And issue is not much.
Two issues.
JV and your
Yes.
local contract.
Yes.
You have given for two, whether it should be for JV or the individual. part.
Individual, that is one aspect. The other aspect is whether there is some sentences are not tallying with the
of
format.
JV agreement, you say you have added 7.
7.
There's one more important point, that historical document.
The document which were there on the last date of thing, you can give, but you will have to
So
establish.
Lordship is fully prepared actually.
You just.
So whenever it is convenient, Lordship, my only submission is if it could be before the vacation, although it is a 10 years contract period, but
Even because বন্ধ হলে immediate because 21st of week হলে 24 to my 9 meetings. With unanswered meetings.
Can we have it on 15th of July?
15th. Lordship, I am not available till 21st of July, Lordship.
Because it's the
In that case, 22nd, it is comfortable.
22nd.
22nd of July.
Just record the presence. Mr. D. Saikar, our Advocate General.
Not as an advocate,
Oh,
as a
sorry,
senior.
Senior Counsel, okay, Senior Counsel. Assisted by Mr. S. Deka, the counsel for the appellants, Mr. K. N. Chaudhary and Mr. Indranil Chaudhary, Senior Counsel.
I am
Along
for
with
respondent number 6, Miller.
Okay, along with the respective
Yes,
instructing
respective
counsel for
respondents.
respondent number 6 and
I'm for 3.
6 and 3.
3 and 4.
6 and 3. Okay, and as well as just there, Ms. B. Dato, Senior Counsel, 3 names together, along with the respective instructing counsel for respondent numbers 6, 3 and
I'm for 3 and 4.
3, 4 and
3, 4, 5 and 6.
3, 4, 5 and 6 are present. Next para. It is submitted at the bar that the hearing would take about 3 to 4 hours. So under such circumstances, comma, the matter cannot be taken up today. Full stop. List on, list for hearing on. It will be ready for hearing? Or it
Yes,
will-
yes,
It's for admission.
It's
Admission
for
hearing.
admission, okay. List in the admission column on
22.
22/7/2025.
For hearing. Or
Admission because it's not yet
for
admitted.
hearing, that will clarify, Lordship, that will give a clear ending.
For admission hearing. Okay.
Admission. Highly applied.
Message.
Item 9.
Your Lordship, we are waiting for our instructions, Your Lordship.
Instructions you are expecting?
Affidavit filed, we have
No,
filed.
no, the rejoinder affidavit.
We have filed.
The reply to দিব লাগিব
We have filed a rejoinder.
rejoinder to আপনি দিলে
Yes. My friend is not aware, my lord.
No,
They
not
find it-
aware, your lordship, let our Mazumdar come, your lordship. He has instructed me, your lordship.
Who has instructed you?
RM Mazumdar, your lordship.
Not the virus of Rule 28 is under challenge, my lord. Both are said.
Ahi sir, Robo. It's not 21 of the other nigga, dada. 21 of the cylinder. Me file for the nigga. Me file for the nigga. I said, no, I'm not file for it.
Nice. May I please, your lordship? Lord, the Rule 28 of the Lord Assam Secondary Education Provincial School Service Rule is under challenge to a very limited extent, my lord. My lord, the issue is that, my lord, in the primary rule, that is Rule 15, wherein my lord, the criteria for the purpose of, my lord, selection to the post of assistant headmaster has been fixed. And in that rule, my lord, the graduate degree is a mandatory degree. Now, my lord, government has recently introduced a policy, my lord, for the purpose of amalgamation of the various categories of upper primary schools, lower primary schools with the, my lord, high schools. Now, my lord, under the amalgamation, they have inserted the Rule 28, wherein, my lord, they have one.
Just a moment.
Not on the episode level, I didn't make it. Rajesh, the Hibo Bola.
Yes.
Lordship may kindly be taken after some time, your lordship.
After some time. Okay.
Or my lord, can it be taken up on Wednesday, my lord?
Today is a day we can take it up because on Wednesday again we are taking up those APSC matters. No hearing will take place. So after some time. Because if we can't take up today, then it goes after vacation. We can't take up in between.
Some personal difficulty on my side, my lord. That's why.
Then it goes after vacation.
And fixed it.
Okay.
Immediately after.
Also is represented on the joint prayer made by Mr. A.R. Buyal and counsel for the petitioner as well as Ms. H. Terangbe.
Terang, lordship.
Terang, the learned counsel for the education department, the matter stands adjourned today. List immediately after the ensuing summer vacation.
May I prefer a date, my lord?
Date is very difficult after vacation. It'll come. It's a division bench order, it'll come normally. You make a mention otherwise.
Oblige.
Item 10,
But in this case, earlier record was called for. And there is an observation that bail will be considered from the receipt of the records. So my lord, at this stage, my lord, my prayer is that she may be allowed to remain on bail of this.
What is the best document you have to
My
connect
lord,
with your projected parents?
My mother was examined. And only because of the name discrepancy of the grandfather,
My lord,
Where is your written statement?
my lord, written statement, lordship will find at page 30. There is a name discrepancy of grandfather. Grandfather was earlier recorded as Toromjan. Toromjan cannot be name, my lord, proper name. It's wrongly recorded and subsequently actual name is Ramjan. That has not been explanation is there, but that has not been accepted. That is the only point, my lord. Paragraph 31, the explanation is provided, my lord. Grandfather is 66, 70, total list, 75 also.
Which page is the opinion?
My lord, opinion, lordship will find that
105.
105.
One zero five.
The opinion dated 14/7/23.
Where is the voter list of 1966 and 70?
My lord, lordship will find that at page 54. '66 voter list.
Because you see, Mr. Sikdar, it's difficult to accept your proposition. Please come to page that 1966 and 70 voter list.
Yes, my lord.
They are from village 113 Kharmuza.
Yes,
Correct?
there was a shifting, my lord.
No,
that
it's
was
okay.
Explained.
Nothing against shifting. Then 1979, same village Kharmuza. Correct?
My lord.
Then come to 1985. Now there is a shifting. At the time of shifting again, Bacha Sheikh is father's name is Tarajan. Now therefore the new village, when the enrollment was done, same name was given. So it's not a case of name of the father wrongly written. Then it is in page 61, it is Bacha Sheikh.
Yes.
Even
Tarajan.
page 63 is Bacha Sheikh. Then in
Ramzan.
then in
Can't
1997, he becomes Bacha Ali. And now again, the village is different.
Seventeen brutalist against his father's name. Grandfather's name is written as Ramzan.
So therefore, we are just wanting to see the connection between
And
you and the projected parents all throughout.
Mother's name is 79 brutalist and 55 brutalist, same, Zorina Khatun. Then in 97 also, Zorina Khatun. My lord, Lordship may kindly have a look at some vernacular brutalist who have collected subsequently, my lord, at page 68. 68, my lord, of 69. 69 father and grandfather are recorded. My lord, grandfather expired, that has not been stated in the.
Somewhere you have stated it is 51, but it is for grandmother.
My lord, grandmother.
Page 31, you said paragraph 12. The first grandmother expired in 1951.
Yes.
His grandfather we are not finding.
My lord, no statement regarding grandfather, but grandfather is also a voter in 97 voter list. 97 voter list. At page 68, father, grandfather in the same voter list. Here, father's name is correctly written as Haji Ramzan Ali. Great grandfather's Junab. Mother's name is Zorina. There is some similarity with the other family members. So, the explanation of grandfather's name maybe ought to have been considered, my lord. In page 70, my lord.
Mr. Sigdar,
My lord.
you have brought on record your grandfather's voters list of 66, 70. But thereafter, what happened? Where
My
are they placed
My
after
lord,
70?
Their the family shifted to Ripur Koraikwa.
Okay, family shifted, but where is the grandfather?
My lord, Lordship may kindly have a look at page 70.
Page?
Page 70. 70 and vernacular
17.
71.
71.
Page 71.
Here, father's name is grandfather's name is recorded as Haji Ramzan Ali.
That is what I-
Grandfather, great grandfather Junab.
If 1966 voters list, he would have been drawn sometime in 1922. Your grandfather.
Yes.
So when did he go for Hajj? If he is a Haji during his normal 60 years,
Well,
it would be sometime in 80, 75, 80. But why the Haji word is not used earlier?
my lord, that was, no, so that was, that writing Haji and non-writing Haji, that,
If he has gone to Haji, normally the concept is that Hajj would be, he would be addressed as a Haji. But why in 97 he is suddenly Haji? If he is alive, where is his voters list?
my lord, Haji, normally people go to in
This is the voters list. That means he is alive. After he's there. When did he expire? Where is the voters list after 70 of your grandfather?
My
Because
lord,
we have to connect two villages, two different
yes,
names.
my lord. My lord,
And your
79
grandmother is not
grandfather is
Tarabano.
grandmother, my lord,
Your
according to
grandmother is
petitioner, the
second one. Second wife.
three grandmothers.
Your grandmother is second wife of Haji Ramzan. Where is she? This is the third wife.
Third wife.
Third wife is not your grandmother. That you have.
Sunabanu is the second grandmother is this. Sunabanu is the actual biological grandmother.
Who?
Sunabanu.
Sonabanu. Where is Sonabanu?
Sunabanu, my lord, in 66, 70 brutalist is there.
But after that?
So 66 brutalist Sunabanu is there.
There is no explanation anywhere as to what has happened to the grandfather, what has happened to the biological grandmother.
Biological grandmother, my lord, 66. Thereafter, she is no more. She is no more.
Have you brought it on record that she expired in 66?
No, that there is no record.
Then how can we presume? Now, if the third grandmother had proceeded to Haripur Khoraikwa with you,
Yes.
what happened to her children?
So children, they are with
So
them.
where are they?
My
And
lord,
what happened to the grandfather?
my lord,
And when did this shifting exactly take place? Which year?
my lord, in 66, 68, page 68,
No,
89
Mr.
brutalist,
Mr. Sigda, when did this shifting take place?
that has been.
That is also not said anyway.
You see, the doubt has started only because of the fact that suddenly your grandfather is referred to as Haji. But his existence is not there. That means from the earlier voter list also his presence is not there. So
Haji returned subsequently.
no, we understand, but you see, after somebody dies, he won't be a Haji.
No. Yes.
So
after death,
he must
But-
have been alive when he did the Hajj. And we are not finding that connect. That's why so many questions. He suddenly becomes a Haji.
But in the 97 brutalist, Haji is written when he was alive. Haji Ramzan Ali.
So 97 he was
97.
alive.
Yes. 97 grandfather alive.
So where is his voters list?
90 plus 70.
Age 70.
Yes.
No. Oh, Ramzan Ali.
Earlier written Ramzan. Here correctly written Ramzan.
So the shifting of the grandfather is not there in your pleading.
No, family entirely shifted. Kindly have a look at my lord, that paragraph 15 and 16 at page 32. page 32. In 79, brutal is there in the original deed. Thereafter, they have, after 79, the family shifted. Parental family of the opposite party shifted from village Karmuza to Horipur Karaikwa in paragraph 16. That means it was after 79-80. And they are recorded as voter in the new village. But grandfather's name was missing. Well, certificate copy was given only with regard to grandmother and
Where have you in your written statement or evidence said about this shifting part?
well, in WS there is a statement of shifting, paragraph 16 of the WS. In what you will find in evidence in see paragraph 12 regarding shifting. Then my lord, grandfather's death has been mentioned in paragraph 15 of the evidence.
15.
Paragraph 15 of the evidence. See evidence in C.
In the meantime,
Hmm?
basically, that was not mentioned. Only say, in the
Statement is
meantime.
there. Mhm. After 79, after 79 shifting.
Okay. If in 97 his father is there, we grant him bail.
Oh.
If in the voters of 97 his father's existence is there, grandfather.
Lordship. Regarding bail, I have nothing to say, Lordship, but opinion is very much clear, Lordship. Last part of the opinion and Lordship.
Once his
there
father's
was no-
existence is there, therefore we will consider that whether can be a spelling mistake or not. Because the connection, some connection is there till 97 at least. But so AR Sigdal and counsel for the petitioner, all the respondents are there. Pursuant to order dated 26/6/2024, the records of the tribunal is received. And the same is perused. Next paragraph. The learned counsel for the petitioner is paid for bail, which is opposed by the learned standing counsel for the FT matters. Next paragraph, considering the projection made in this petition. And noticing that as per the submissions made by the learned counsel for the petitioner, the existence of the grandfather of the petitioner can be traced out till the voter list of 1997. The records would require further examination. Next paragraph. Therefore, at this stage, the prayer of the learned counsel for the petitioner for bail is allowed by providing that conditions in the order. Those two conditions will be there. 10 days time to take bail out of this 5,000 to the satisfaction of
SPB Golpara.
SP border Gwalpara.
deep level.
Just next, you say, as the records are received, call the representative stands admitted for hearing by issuing rule returnable forthwith without any fresh steps to be taken. Next matter is the matter for hearing in the month of August 2025. Yes, so now you got the, for the criminal repetition, you are there?
Yeah.
You got the informations?
Item 11, Manoj.
Yes.
Item 11, Manoj, in the, we have filed an affidavit, and then bringing that report there, Manoj.
You bought it?
Yeah.
Okay, then we'll take it up.
Yes.
Item 11 for admission.
Notice the vote.
If it would come to my side. Notice of application exists. Good. Yeah. Notice of application exists. Notice में जाना है. Notice तो वो complete है जैसे. Yes. Okay, different course.
Is the police station's GD entry available?
Well, the GD entry is not available.
In the magistrate inquiry,
One.
they've also not referred to the GD entry of 21/10/2024.
2110, he was in hospital and he was arrested, but the incident took place on 1610.
1610, I'm sorry.
Lot.
1610.
Malad.
Lordship, but GD entry number is available. In the page number 19 of the writ petition, Your Lordship.
19.
19, Annex 3. But.
No, we are not on that. In this magisterial report, since we did not have time to go through it,
Lordship.
we're just asking you, is the GD entry referred to in respect of 16/10/2024?
Lordship, as regard the ministerial inquiry in Lordship, I have certain submission to be made.
Please respond to the court query. We'll hear you.
Copy is not with us.
No. We are just, the only question we are asking is a reference to the GD entry of 16/10/2024 referred to in this ministerial inquiry? Any incident which happened on 16/10/2024 is a corresponding GD entry referred to in this inquiry.
It is not reflected.
You see, we are referring to only one issue of that GD entry. And if it is not available, we may reject the affidavit filed by the Superintendent of Police and presume that it's a case of the purposeful shooting.
Yeah, right now I don't have, I don't have the copy, I can produce that, that has to be.
But this affidavit, you see, with this, otherwise also this affidavit has no sanctity. It is not acceptable, this affidavit. This Superintendent of Police, he has filed this affidavit and is a responsible person, unless you say that yes, this particular SP is not responsible person. We have to presume that this Superintendent of Police is a responsible person. And in his affidavit, which is at page 71, you come to paragraph 6. Now, which part of 6 is matter of record as per page 81? We don't know. Which is a part which is matter of personal knowledge, that also we don't know. Now, this is very essential because of the fact that in paragraph 6, you say that he was traveling with the OC Simlaguri police station, and he then pulled the rope, started running, and the OC Bogota Nemuguri PS warned him to stop. But person did not pay heed, he kept running, and therefore the OC resorted to blank fire. This person fell down. Now this can't be personal knowledge. Either if the SP was there, then something else. He will say that yes, I am there, and therefore my personal knowledge. What happened? We saw this person's running and all, so it is within my personal knowledge. Otherwise, it would be a statement made by the OC of Bogota, Nemuguri police station, who actually fired. And then the GD entry is not there. So in a police communication, there must be some record kept,
Has to be, my lord.
because this is at night.
At-
I don't think this OC will be uh, with this incident of air firing. He would just call up the superintendent of police and give him time to time development of the case.
My lord,
OC will not normally call up a superintendent of police. It's not expected. So
But-
how will be this how will this be a personal knowledge? It won't be.
my lord, some
And in
part.
the ministerial inquiry does everything but does not need the GD entry. And that is required because of the fact that one bullet was used. You'll have to be accountable for one bullet.
Correct.
How was it accounted for?
But I'll place the diaries, bro. The GD entry and other materials, but I'll place. Right at this moment, I don't have, but have
You
to
place it because what happens is that you see now we have one question, tomorrow we may have another.
my lord.
So piecemeal, we can't apply our mind.
Well, in fact, as per the instruction of the SP, with the local police station and the other police station, well, they went they went to that particular place, bro. And they took the petitioner in their custody. And it was in fact as per the direction of the SP only that
Operation was conducted.
SP gave the direction that you can shoot him at the leg. No.
not that. The ultimately the person was picked up. He was taken from his home as per the direction of the SP. That the GD entry I'll place. I'll place. In fact, I'll place. Otherwise, in the report, the statement of both the OCs of Bogota and the Demo police station, both are there. I'll place the GD entry.
You see, we are not satisfied with this this ministerial inquiry report at all. We have not read it, but we take your word and your word of Ms. Begum saying that sorry, Ms. Hussain saying that this reference to GD entry is not there. If the GD entry is not there, how will you get a armory report? How will that an because this this was an incident of 1610. Ministerial inquiry is in December of which year?
24.
2024. That means after how many years?
No, 16/10, 2024.
After 2 months. After 2 months.
After 2 months.
So after 2 months, by then the armory report would have been prepared.
By kindly see the reference by 19/10/2024, the magistrate inquiry was requested. Incident took place on 16/10. In the report, kindly see the statement of the victim at page 98.
Asif,
That 20% moving GD entry person. GD का वही अगर ध्यान है तो. So
In fact, we don't see any purpose to call for the police records and to make any further inquiry. My esteemed brother has pointed out, come to page 67. This is officer in charge, SI Parmananda Saikia, who's writing this FIR to himself, addressed to himself. This FIR, at page 65, is at 3:30 a.m. Huh? 6 a.m. on 16/10.
But he was picked up at around 2 a.m. Your Lordship.
At 2 a.m.
2 a.m. and the FIR is 3:30 a.m.
No, this was after the incident took place. The incident of the alleged encounter. He mentioned that incident.
That's it.
This FIR is
This is
the FIR is registered when?
that's it. The main FIR is on page 19, Your Lordship. Page 19.
19. Okay, is the injury report available?
Medical documents, they have given at page 42 or 43 in the writ petition.
Page 43 onwards is the normal report. Post arrest of 2110.
Lodge,
Incident of occurred on 1610.
1610.
Lordship, in page number 86, there is a discharge certificate from the hospital, AMCH.
86.
Page 86, Annexure B. Brief history is on page 87. Patient was brought to AMCS casualty by police on 16/10/24 at around 6:34 a.m. with bullet injury during police encounters caused around 3 a.m. on 16/10/24 at Sepon, Ranapara Road, Shivsagar.
What's the typical information by student? It will take some time. So, it will take some time. Another person will be if the deportation will indicate the proper.
Is this the complete report? Is this the complete report?
No, Malad, this is the discharge certificate. These are the
The
magisterial inquiry report, Malad, that is the report, and the report contains the statement of the person, Malad.
No, you can come down to page 91.
91. Malad.
So the procedure adopted has been laid out.
Lordship, procedure.
Come to clause 4, FIR and GDE report analysis.
Yes, Malad.
Where is that?
In fact, page 100 is the conclusion.
Where is that analysis?
Separately, I have not seen, although procedure has been mentioned, Malad, but because these are the statements.
Where copies of the GD entry and the FIR and the statements all made part of that report?
In this branch, Malad, I have not seen, because this contains the statements of the persons, all the persons, Malad.
GD entries?
I have not seen here.
But you see in this report, there's no mention about any appendix to this report. So therefore, we must presume that page 89 to 100 is a complete document.
I think so, Malad, because this is the report.
So if there is no document referred to,
Yes, Malad. The statements have been recorded separately. Those have been extracted in the report, but I have not seen any appendix, Malad, as Lordship has pointed out, Malad. But the copies have been given to me. That bunch is, I have. At page 100, Malad, there is a mention of the GD, but at page 100, serial number 1.
ये 1610 का incident number 1.
Detail analysis is not there. Page 100, kindly see serial number 1.
Team number on 1611. Number 4, 1611. 1610, 1611. 1611. Right. अभी फिर लेने के 1610 को 1610 के मुझे रिपोर्ट के लिए this is the self-contained report. Second 24. 1610.
Our contention in the writ petition is that the petitioner's husband was shot from a point blank range, and how one single bullet injury could lead the petitioner to amputate his leg. That query is not.
For that, you see, for that the state will not give you an answer to that query. For that query, you'll have to understand the dynamics of the what you call this medical appreciation of evidence so far as this gunshot is concerned. The place where this gunshot entry was there is what you call it is right leg. What is it?
Below the knee.
I'll just tell you. It is distal femur. You know the location?
No, you're not.
I don't know. And you know the implication of a open wound in a distal femur fracture? No. The medical books say that if there is an open injury and in the distal femur fracture, those are very susceptible to infection at no time it can contain infection, it can contact infection. And therefore, and do you know the protocol of amputation, limb amputation? You know the protocol? No. Unless the doctors arrive at a finding that it will be very, it will be causing fatal injury, sorry, it will lead to death.
Death.
If that is imminent, then only they take recourse to the amputation of hands and legs. So that would be the first finding, that it will lead to a gangrene and it may infect the entire body. So therefore, either this or its occurrence of sepsis, if it occurs, then a decision to amputate is taken. So therefore, the answers you will not get from Mr. Nath.
Then to the impact of a bullet injury.
It may happen. You see, even 2 hours is good enough time for an infection to set in.
But Lordship will kindly see page number 96, in which the assistant professor of orthopedics in AMCS has said that
Let me tell you in a very simple language.
Lordship.
I know a person. It's a personal knowledge. I am not using it here for this purpose of this case, but it's a personal knowledge I am telling you. In a market area, which is very close to a hospital, a man was riding in a rickshaw. He was hit by a motorcycle. This man fell down from the rickshaw. He was immediately taken to the hospital, which is not even half a kilometer away. And in the hospital, the first decision taken was to amputate his hand. He lost his hand from here. There are 2 hours difference between the accident and the amputation. And it is within this time that gangrene was setting in and had to be amputated. The right hand of the person is amputated. I know that man very closely. That's why I know about this incident. And by the time we reached from my place to the hospital, the decision and the operation to amputate the hand had already occurred. So
Like here,
therefore, this is a protocol. And amputation, you see, the police may be against you, but a doctor will not. So by the protocol of treatment, when they amputate, it means that the infection has set in or sepsis has set in. But the problem is that that's why we are asking for the GD entry, because if it is not there, then the actual site at which the bullet injury took place, we are unable to say, except for the medical opinion which says that there was a open wound at the distal femur, and distal femur is just below in the lower part of the thigh. So the time we were spending to look at things is actually to read medical.
Moreover, also
In the meantime,
incident took place on 16/10 and the amputation happened on 20th of 2010. After
so that's why you see we are not aware of the decision taken and the fact, because it's an infection which is setting in. So unless we know that.
In fact, on the same day, there was an operation. On 16/10, operation was there. But subsequently, after 3 days, this decision for amputation was taken.
So we don't know. That's why we are asking for these things.
From
The
page
documents are not there.
Page 96.
on negligence of the police personnel, Your Lordship, as per the assistant professor of AMCS orthopedics, the incident took place around 3 a.m. And as per the doctor in the demo medical, the person was brought at around 4:30. And as per my instruction,
36. Somewhere it was 3:36.
No, Lordship, Lordship will kindly come to page
96.
96.
Both the
Your Lordship.
doctors.
No.
96.
No, there is something more. Page 87, 3 a.m.
Lordship, 3 a.m.
Patient was brought to AMCH causality at so-and-so around
At 6:34 a.m.
6:34 a.m. Bullet injury encounter 3.
From the place of incident, immediately he was taken to demo. Then Demo referred to AMCH, he was taken to, here, he was taken to AMCH.
No, somewhere I read three,
Three, Lordship,
maybe.
page number 96, a statement of the doctor of orthopedics.
No, this place when he was taken to that CSC, what was the time?
Timing is 4:30 a.m., Your Lordship. Already at 1.5 to 2 hours late, Your Lordship. There's negligence on the part of the police personnel. It is page 96, first paragraph, Your Lordship.
96.
First para. Mr. Rahul Hazarika was brought to our hospital at around 4:30 a.m. with history of firearm or bullet injury.
Oh, 3 a.m. is bullet injury. Okay.
Injury.
Lordship.
3 a.m. is the injury.
It's the bullet injury, and he was brought to the.
So that's why you'll have to tell us about this time lag of 3 and 6. How it would be fatal.
As per my instruction, the distance is 65 kilometer. It takes around 1.5 hours, Your Lordship. Okay.
Medical report to another.
Moreover, Lordship will kindly say how the ministerial inquiry was conducted. Only 12 statements are recorded. 3 are family members, 2 doctors, and the rest 7 are the guilty police officers who were directly or indirectly involved in the alleged crime, Your Lordship. This is how the inquiry report was concluded.
Please tell us who were the proper persons whose statement could have been taken under such circumstances.
Now, so at least a scientific investigation as to the because the petitioner's husband's claim is that he was not running away, he was shot at from a point blank range. At least some.
I understand. I appreciate what you are saying, but please tell us what was the scientific investigation.
As regard the impact of a bullet injury, the distance.
But that evidence is not there. That is why we were reading that medical evidence. The arms were amputated and it was severed. So therefore, that bullet injury will not be available.
At least it could be called for proper investigation.
I don't know. You'll have to tell us. Now, please tell the protocol. If supposing the finger of a person is amputated. Now you are trying to say that this has to be preserved. For that, some steps would have been taken.
As regard the impact, Your Lordship, impact of the bullet injury, because I have the photograph, Your Lordship. For the photograph is annexed.
To us.
Annexure 9, Your Lordship. Page 42, Your Lordship. A young boy of 34 years, Your Lordship. Lordship, can this happen when
Just trying to ask. Page 42 contains a photograph of a person whose leg is amputated. One leg, which appears to be right leg, was amputated, correct? In left leg, there is a bandage, correct? Now, this position of the first photograph, mentally please turn it around 180 degree. And then come to the next photograph. So this appears to be a left leg again. Correct. This man is now, the position is upwards. From here, I am taking the photograph of my leg. So it will be a left leg. But then, madam, this left leg is not the portion which was amputated. The bullet injury was in right. And then you say that please look at the photograph and please look at the impact.
Lordship, but the
The
statement. that the
inquiry,
position is only
inquiry is
one
not for left leg. Inquiry and the case we are hearing from you is of the amputation of the right leg.
Right leg.
So where is the evidence? It is not there.
There is only one bullet that is fired as per their
We
statement.
don't know. That's why we were wanting to look at the GD entries. Unless we have a GD entry, we will not be able to understand. And in the case diary, there will be corresponding entries of what has happened.
In fact, because
When we were looking at the records for quite some time without speaking anything, we were evaluating the evidence which is there before us. But please
because
tell us, in this light of this medical evidence, forget about us. What is the conclusion you can draw as a counsel assisting the court?
because of this page 42 confusion in the prayer portion, Malad, they have in fact mentioned that they have claimed for compensation for amputation of left leg.
No, that's
But
because we can while looking at this, we are not so deep into the pleading.
The evidence of the doctor at page 96, it throws light. Why? Ultimately, after 4 days, they have taken the consent of the family members and ultimately the amputation was done. In fact, second paragraph of his statement, kindly see, Malad, page 96.
No, but there's something more into it. We are unable to locate that.
But
Please
as per
produce the case diary, complete
Yes.
case diary.
Logic.
as per
Logic. I'll
statement of
produce.
all the 7 police officers, only one bullet was fired at the person.
One.
So,
Bullet is one.
one is fired in the air and other on the leg.
I don't know. I can only say that at times when I was in college, I used to love those what you call Western movies. Plenty of wonderful people. With only one bullet, they could have done so many things. I just have memories of those good movies I saw then. So I won't comment on why one bullet, why 7 people, why one bullet. An injury has happened. Nobody is denying that it's not a bullet injury. So no, the state is not trying to justify. Rather, it is your claim that that there could have been more policemen to guard a person who has got down for urinating. And in this case, what had happened was that this man was in the handcuffs. He was in ropes. Rope was being held by the OC of that
Police station.
police station. And this man tugged the rope, it slipped from his hand and he ran away. He gave a warning shot. As per the police version, he gave a warning shot in the air and the second bullet was in his legs.
But two
So-
legs are injured. 2 legs are injured.
No, we don't know. This second injury, we can't say it because
But
this is not a bullet injury at all.
even if
second-
even if we ignore the statement of the other, the statement of the victim, it is also there, Malad, at page 98. He says.
We can't apply our mind without the case diary.
Lordship,
We produce the
I'll-
case diary.
definitely, I'll place it. I'll place it. He also says that only one bullet. I'll place the case there.
And here also, please take the assistance of someone from this, the IO or the OC, whoever is there, who's available.
Follow.
Before you place the case diary before the court, you just ask them to find out if there's any missing link.
Lordship, I'll try.
In the case diary.
Yes, definitely, Malad. I'll try to get the entire.
Because once you have the case diary, then there's no asking a question or giving you a further opportunity to
Have some more.
to have
Lodge.
more documents.
Lordship.
All sides are represented. So next para, in order to appreciate what is actually what has actually happened on 16/10/2024, on the date of the incident, and to appreciate the ministerial inquiry report which has been placed wide. Affidavit in opposition filed by the respondent number 6 and 7 on 19/12. No, sorry, 7 January 2025. The court is inclined to call for the case diary of Nemoguri PS case number 11 of 2024, right? 11 or 12? It will be 12.
It will be 12.
Well,
After the incident, Nemoguri PS
It's
12
12.
12 was registered.
No, then both 11 and 12.
Lordship.
11 of 2024 and 12 of 2024.
Lordship.
Next para, it is provided that in the event the learned Mr. D. Nath, a senior government advocate, requires any assistance to for the perusal of the case diary, comma, the Superintendent of Police, Sivsagar, shall do the needful so that the investigating officer of Bogota Nemuguri PS case number 12 or 2024 if currently available, would be spared to assist the learned senior government advocate. Next para, list on. If he is available, the Superintendent of Police, Sivsagar, will do the needful to make him available.
Lordship.
Police administration department. Don't write SP, the Assam Police Administration. Yes, yes. Yes, page 99. Huh? Yes, my esteemed brother has found out. We were reading that on page 99. Statement of Rahul Hazarika. This is the injured person.
Yes,
It starts from 98, last line. Thereafter, they took me to Dimon Hospital where they tied something on the wounded knee and I lost my sense. On the same day at about 2:30 p.m. operation was done. So now he's at 2:30 p.m.
at AMC itself.
It should be.
This
Do you-
perhaps I read it as to 3 a.m. It's 2:30 p.m.
PM.
As per this, about 2 rounds fired, and it paid 93, 3 rounds. Hmm. There are some gaps.
Yeah.
I think I misread that to be 3. Okay. List on. 15 days time would be enough.
Lot. After 2 weeks.
Give a date after 15 days.
Mhm.
25th. 25th June.
Deeply obliged, your lordship.
That bunch I'll take that or.
Yes, yes, yes.
Lot.
Deeply obliged.
Upgraded item 21 with 22 for orders.
Do you have instructions? You have received the compensation amount?
Yes, no, but instruction is there, but they have not received anything.
Yes.
Well, a report was called for, so far my knowledge goes from the member secretary DLSS. The people just.
Okay.
The people just-
All sides are represented. In terms of order dated 9/5/2025, or the registrar shall call for a report from the member secretary, district level services authority, Barpeta, to inform the court as to whether
This one, yeah.
compensation, interim compensation amount of rupees 2 lakh ordered to be paid to the petitioners, namely Kad Bhanu, last order, paragraph 6, Kad Bhanu and number 2, Saiful Islam. Which was ordered to be released by the District Legal Services Authority as and when the funds are placed by the Home and Political Department, Government of Assam, or any other concerned authority. Next paragraph. The registry shall transmit a copy of order dated 9/5/2025, as well as the copy of this order to the member secretary of our District Legal Service Authority to enable the said authority to send a report. Next paragraph, list on what happened? 18/6/2025. But what is your instructions? They have gone to the DLSA? No.
No, my instruction that they have not received anything.
No, not received is something else. Where they have gone and whether they have been turned down, saying that it's not, the money has not come or
No,
something.
they have not gone, not start down corporation doesn't right, because they have not gone.
Pardon me, I did not get it. We did not get it. Please repeat again.
That means they did not go there, but.
Without going, they will not receive money.
But notice has to go from this.
Why notice? We have given you an order that you will appear before the District Legal Service Authority and will go. If you still want a notice, then it will be the moon which is very far away.
They have informed that they would issue notice thereafter.
Oh, then you keep
That
on
was the
waiting, then
understanding.
we can't do anything. Then they are smart people, let them wait for some time.
Let me go.
Let them wait for a notice.
My understanding is that there was that.
No, why notice? The order does not say that you go and without notice, they will not make payment to you. All you have to do is take the certified copy of that and go to the DLSA to get payment.
Yes, yes, I got. Second case, that is same order. Same day it will be heard.
Similar matter.
Similar, not similar.
Similar. We
Same-
just tag it with.
Yes, same incident.
No, this is a little different. This is a little different.
Mhm. Yeah, you're right. You're right. In the second order, they say just list this matter along with. Firstly, all sides are represent. List this matter along with the connected WP criminal 6 of 2022 on so.
Item 12 for admission.
Lordship, this matter may be taken up on 13 June along with WPC number 302 of 25.
No, it goes after vacation. List as prayed for by learned counsel for the petitioner. No, just the learned counsel for the petitioner prays that the matter be taken up along with WPC
302 of 25.
25. Accordingly, matter stands adjourned today. List this matter along with WPC so and so after the ensuing summer vacation.
Obliged.
Item 13.
Please, Your Honor.
May it please your lordship. My lord, in this case, we are to file our affidavit. We have received instruction, my lord, but we need some more instruction to make our affidavit. As such, I'm praying for some time
You should have
to
informed this,
prepare and file.
and he seems to be coming from outside. You would have saved some trouble.
Anyway, my lord, unless reply comes,
I understand, but since you are outstation counsel, you could have been informed. You could have joined us from video conferencing. Since he's out of station,
My lord.
if given earlier information, he could have joined us from.
Oh, my lord, I'm sorry, I'm
no,
sorry.
no, not at all. If the instructions are not with you, you
Okay.
can't do anything. Anyway, my lord, I'll come again.
Okay. Ms. Crowe, how much time?
3 weeks' time, my lord.
Give a date so that Mr. Pandey knows when he's to come.
After holiday, my lord. Summer.
Just give a date so that he knows when he's to travel.
Lordship. 15th?
15th of July.
15th. No,
You make it
15th.
16th. 15 is
6. 18. 16.
Lordship, some more time is needed to ask also. Some more time is needed to ask also, Lordship, some more.
no, but you see, your government has already taken a decision.
Lordship,
Ah,
already it's been
so-
implemented and it's going
So
swiftly.
this,
my lord.
therefore, so far as you are concerned, you will not require much time. And for respondent number 2, you are appearing. What is your what is your involvement in this? The state of Assam is
Yet to receive
has got nothing to do. It's a
Pharma party, my lord.
you're only pro forma.
Party.
Please,
This is a ILP required in the state of Nagaland.
Nagaland, yes.
Because of certain orders passed that this court was given he was given liberty to move this court.
16 July, as your lordship has.
So you'll file the affidavit at least one day in advance
Lordship,
with
we should-
soft copy to him by email.
Lordship.
Okay. Mr. S.N. Pandit, counsel for the petitioner is present. Also for the counsel for the petitioner, as well as Ms. R.B. Bora, the learned government advocate for the respondent to are present. Next paragraph. Ms. T. Crore, learned additional advocate general for the state of Nagaland, representing respondent numbers 3 and 4. Pays for some more time to file affidavit in opposition in the matter. So she has submitted that the instructions received are incomplete. Next, but accordingly, lists the matter on 16/7/2025. So the affidavit in opposition shall be filed at least one day in advance, with soft copy being emailed to the learned counsel for the petitioner. You give her your email address so that she will be able to do so. List on so and so.
Lordship.
Item 14.
Grateful, my lord.
My lord,
Mr. P.J. Fukan, learned counsel for the appellant is present. Next. This is the matter before any other bench without one of us. And Krishnan Nair. Yeah. You want a fixed date?
no, my lord, needed next week, my lord.
Next week. Okay, you are for?
I'm for a private respondent.
Respondent
Okay,
number.
your name?
Respondent number.
Give your name to the court master. Counsel is respondent, private respondent present. Mhm. List on, make it next Monday. Next Monday will be
16/6.
16/6/2025. Okay. You want it next week?
Next week, my lord.
16 June.
18th.
18th.
18th,
18th.
okay,
Lordship fixed any other day, Lordship.
not on 18th. Mr. I forgot. I constantly each other.
Seventeen, 18, in 18, not only 20. 20.
20. Okay. Okay, I don't think we'll have more time to, because we'll have to rise for the single bench. Yes, Mr. Sharma.
May I please, my lord, I think 24, my learned friend, Mr. Chaudhary is also hearing.
We'll have to rise for the single bench.
My lord,
We'll have to rise for the single bench.
my lord, the matter may be posted for next week, my lord.
My lord, there is a urgency in the matter. There is a stay order operating. We have not been able to finalize a tender. Now there is a stay order operating, my lord. They have not participated in the tender, but there is a stay order. My lord, let this matter be called day after tomorrow, my lord.
The day after tomorrow.
It's a catering conflict.
Tuesday, my lord, next week, Tuesday, my.
No, Tuesdays we are reserving for
The other matter.
few other matters.
Wednesday.
Day after tomorrow.
Monday?
Day after tomorrow, Wednesday.
No, my lord, next week, Wednesday.
Monday,
17th.
Monday then?
Monday?
16.
Monday, let it be
17th.
16th, 18th, my lord.
18th.
Okay,
Wednesday.
okay, this is Providence. Even if you don't believe. Mr. Kane Chaudhary, Senior Counsel for the appellant,
Yes.
along with his learned instructed counsel and what you call, you're appearing for all the respondents?
The sole respondent.
The petitioner respondent.
Yes, item number
24.
24. Okay. Along with the Mr. R. Sharma. Learned Senior Counsel with this learned instructed counsel are present. Next part, some urgency is expressed in the matter. So accordingly, list the matter on 18/6/2025.
My lord, next item, item 15, is listed for first time today. Maybe day after tomorrow, my lord.
This item Wednesday. Item number
Item
15.
15, my lord.
Lordship, can it be taken on 16th, Lordship? 16th, Lordship.
Lord, there is some urgency, my lord.
Okay, Lordship.
No, because we have a lot of those patent matters and these special benches coming up.
Wednesday, Lordship.
Wednesday.
Wednesday.
Wednesday is
Wednesday 11, my lord.
Wednesday is
11.
11. Any
11.
difficulty on that day?
No, Lordship.
But then we fix it on Friday.
Friday, Lordship.
Friday. Okay.
Yeah. Some urgency was there, my lord. Interim
I
prayer.
understand, but since she is expressing difficulties, Friday will be
13.
13.
13.
Okay.
Highly obliged.
Yes, Mr. Saira.
Well, item 25, my lord, the other side has not filed the affidavit yet. What, my lord, it may come up on 20th, my lord. 20.
20?
Okay, 25, 20.
That's fine.
Twenty 25. Both sides are represented. Mr. G. N. Saura, as senior counsel, along with his learned instructing counsel, has submitted that there is some urgency in the matter. This not 26, 2025.
20.
Oh,
20.
20, 26.
Yes.
It's just Mr. Academic Chaudhary is DSGI president. Yes.
Stated that the grounds of arrest should be communicated to the petitioner, which has not been done. So first of all, Your Lordship, one more thing before going into that, I'd like to point out there were 12 listed witnesses in this matter, prosecution witnesses, out of which only 3 has been examined till date. About 2.5 years passed, and till date only 3 has been examined out of the 12 witnesses. So on that ground also there is a long inculcation part which I'll come later. First, Your Lordship will kindly take up page 23. Page 23 is the notice under section 50 of the CRPC. In this notice, Your Lordship will see the name, address, and the sections have been informed, has been given, and it has been stated, you are hereby informed that you are arrested in connection with the above reference case, and the case is non-bailable, so you are forwarded to the court. You may submit petition with the honorable court for your bail. So here is the notice under section 50 does not contain in any manner, even not a single whisper which says that these are the grounds for your arrest. No whisper at all in this section 50 notice. This is the type copy. The next page 24 is the copy of that notice. So my first ground is this non-supply or not providing the grounds of arrest to the petitioner. Nothing has been provided here. In this regard, Your Lordship, I will rely on some decisions. And these decisions, Your Lordship, in fact, in this case, they have also filed one objection by the respondents. In the objection, this part has not been dealt with regard to the grounds of arrest. They have mainly stated the basic facts and the merits of the case. And without going into the fact that the grounds of arrest, with regard to that, they have not stated that they have provided the grounds of arrest to the petition. That has not been stated in the objection petition. Your Lordship, I'll provide some judgments which I'll rely today. If Your Lordship has time, I'll give copies of these judgments. A set of judgments I'm giving Your Lordship, one by one I'll refer on this grounds. I'm not going into the facts of the case because Your Lordship, basically it is on the point of violation of the constitutional mandate of Article 21. So Your Lordship, first judgment that I'm referring is Directorate of Enforcement versus Suhas Sarma. I have written the citation, that is 2025 SSC Online 240. Here I am relying on only one paragraph, paragraph 8. Paragraph 8, Your Lordship, in the second page, last paragraph. May I read the paragraph?
Yes.
Once a court, while dealing with a bail application, finds that the fundamental rights of the accused under Article 21 and 22 of the Constitution of India have been violated while arresting the accused or after arresting him, it is the duty of the court dealing with the bail application to release the accused on bail. The reason is that the arrest in such cases stands vitiated. It is the duty of every court to uphold the fundamental rights guaranteed under Article 21 and 22 of the Constitution. And then next paragraph. Therefore, when an arrest is illegal or is vitiated, bail cannot be denied on the grounds of non-fulfillment of twin test under clause 2 and so PMLA. In this case, it was PMLA, but overall, Your Lordship, in a case where there is a violation of Article 21 and 22, bail have to be granted. That is what the court has stated, Your Lordship. This is the first judgment, and then Your Lordship will kindly take up the second judgment. This is not with regard to grounds, Your Lordship, but court has specified that in both these fundamental violation is there. There's nothing else the court should do. It should grant bail. Now Your Lordship will take up the second judgment, that is Ashish Kakkar versus Union Territory of Chandigarh. I've given that copy.
Since I am to, what do you call, disconnected for a few days with this bail matters.
Lordship.
May I ask you, this grounds of arrest, according to you, must be given at what stage? Or within how much time of the arrest, or without giving a grounds of arrest, it can't be arrested at all?
My submission here, your lordship, from the judgments which I have seen, because these are only basis of the judgments. What I have seen, the grounds of arrest should be given as soon as possible. The
As
word
soon
used is as soon as possible, immediately after arrest. I'll come to that. The judgment itself has said, I'll come to that. That is there. And then, your lordship, it is not given, your lordship. Then even the trial will continue, but there will be no stoppage of the trial. Trial must continue, but what happens, your lordship?
Entitled bail.
Since the arrest has become illegal, therefore bail is entitled. Normally, your lordship, if in a one sense, that is my mind, I'm just speaking it up to your lordship. When arrest becomes illegal, is it necessary for a bail? Bail itself is there. But anyway, since court says that, I'm on that. The second judgment, your lordship, kindly take it up. Assis Kakkar versus Union Territory of Chandigarh. Here, your lordship, while the paragraphs are not named, in fact, this judgment, I did not get the citation. I've taken it out. It was on 25th of March, 2025, your lordship. The third paragraph, your lordship will kindly take up the third paragraph. We are inclined to consider only, there were 3 grounds raised in this case, so court has taken 1 ground, that is why I'm reading that. We're inclined to consider only the last issue raised by the appellant with respect to the non-furnishing of the grounds of arrest. This lordship, just before I am reading that, one thing I'd like to point out, this case I have submitted because there are 2, one is a grounds of arrest under section 50 and one is memo of arrest. So here the distinction will come, that is why I'm reading that. With respect to the non-furnishing of the ground, upon perusing annexure P3, we can see that what has been provided to the appellant is only an arrest memo in the prescribed format, which is meant to be given to the appellant by way of an intimation. It has been filled up with the name of the appellant along with the place of arrest. Additionally, it has been written that he has been arrested based upon the statement of the co-accused. We are in agreement with the submissions made by the learned senior counsel appearing for the appellant that the said arrest memo cannot be construed as grounds of arrest, as no other worthwhile particulars have been furnished to him. So here, your lordship, the arrest memo was given where something has been written, name, addresses, and also the statement of the co-accused on which he was arrested. But court says the arrest memo cannot be a ground of arrest. Grounds of arrest should be as per the notice under section 50. So in the next paragraph, it says, this being a clear non-compliance with the mandate of section 50 of the code, which has been introduced to give effect to Article 22(1) of the Constitution of India, we are inclined to set aside the impugned judgment, particularly in the light of the judgment rendered by this court reported in Pravi Prakasta versus NCT 2024 8 SCC so. In such view of the matter, the impugned judgment stands as set aside and the arrest of the appellant followed by the consequential remand order also gets set. So, your lordship, subsequent and consequential remand orders were also set aside and he was given bail. So basically, here I have to point it out with regard to memo of arrest and ground of arrest. Now, your lordship will kindly take up the third case, that is in Madhu Limaye versus unknown. And this is some unknown, I don't know why it has been unknown, but anyways, your lordship, this is the equivalent citations are given. I'll refer to 1969 1 SCC 292. So here I will also rely on, your lordship, the paragraph. Here, your lordship, I rely on paragraph 12. Married. Once it is shown, this is an old matter, your lordship. This issue was in 1969, 62 itself was first raised. Now it has come in 69. Once it is shown that the arrest made by the police officers were illegal, it was necessary for the state to establish that at the stage of remand, the magistrate directed detention in jail custody after applying his mind to all the relevant matters. The state has failed to do so. The remand orders are patently routine and appear to have been made mechanical. All that Mr. So-and-so has said that if the arrested person wanted to challenge their legality, the High Court should have been moved under appropriate provisions of Criminal Procedure Code. But it must be remembered that Madhu Limai and others have, by moving this court under Article 32 of the Constitution, complained of detention or confinement in jail without compliance with the constitutional and legal provisions. If their detention in custody could not continue after their arrest because of the violation of Article 22(1) of the Constitution, they were entitled to be released forthwith. The orders of remand are not such as would cure the constitutional infirmities. So here the word is orders. That is what I am trying to point out. That means, Your Lordship, subsequently, after initially he was produced before the magistrate remands him. Thereafter, whenever he is produced, in the case of evidence or whenever, then orders of remand are always produced. So what happens when the initial the non-compliance of the Constitution, Article 22(1) is there, all the orders of remand subsequent are, Your Lordship, will not cure the infirmities, and so they are illegal. That's what it tried to point out. And here, Your Lordship, court in para 14 granted bail. We would like to make it clear that we have ordered the release of Madhu Limai and other arrested person with regard to whom rule nisi was issued on the sole ground of violation of provision of Article 22(1) of the Constitution. We desire to express no opinion on legality or illegal. This part court has not given opinion, only on the basis of 22(1). He was, Your Lordship, given bail. Now, Your Lordship, the fourth case that I am relying on is with regard to Prabir Purkayas. That is reported in 2024 8 SCC 254. Prabir Purkayas, I have given that also. This Prabir Purkayas, para 20. I'm starting with 20. There are a few paragraphs which I will rely in this
Just
case.
a moment, this Madhu Limai, you are relying on paragraph 12 and 14.
12 and 14. 14 only first part because it has given bail considering only the point of 22(1).
No, because I forgot to write. That's why.
Okay. Lordship, then in Prabir Purkayas, I'll give the paragraph one by one. Paragraph 20, I'll start. Paragraph 20, Your Lordship will find in the page 11. Pages are given down below at the right hand side. Page 11. Para 20. Result 10 starts. There is no doubt in the mind of the court that any person arrested for allegation of commission of offences under the provisions of UAPA or, for that matter, any other offences has a fundamental and a statutory right to be informed about the grounds of arrest in writing, and a copy of such written grounds of arrest have to be furnished to the arrested person as a matter of course and without exception at the earliest. The time is not given, it is earliest. The purpose, now the purpose is given, Your Lordship, why it has to be done. The purpose for informing to the arrested person the grounds of arrest is salutary and sacrosanct, inasmuch as this information would be only effective means for the arrested person to consult his advocate, oppose the police custody remand, and to seek bail. Any other interpretation would tantamount to diluting the sanctity of the fundamental rights guaranteed under Article 22(1) of the Constitution of India. Now I will go to para 22. The right to be informed about the ground of arrest flows from Article 22(1) of the Constitution of India, and any infringement of this fundamental right would vitiate the process of arrest and remand. Mere fact that a charge sheet has been filed in the matter would not validate the illegality and the unconstitutionality committed at the time of arresting the accused and the grant of initial police custody remand to the accused. So it says that even after charge sheet and subsequent process, even then, if it is not, if the initial arrest is not validated, the illegality, unconstitutionality is there, then nothing remains, Your Lordship. Now, Your Lordship will kindly take up para. Here, Your Lordship, the court has subsequently gone through many judgments. I am not reading all these judgments. Resication is taken first because that was in 1962. I'm not reading. I brought that file, but I'm not reading because that was with regard to detention, preventive detention. Now that in that court has stated in this case that the grounds that given in a preventive detention, as the lordship knows that there are certain grounds given for a detention of a person on the preventive detention, whichever act, that should be the procedure of the grounds given here also in this case where a person is arrested. So it should be the similar. That means when it is a preventive detention, it is 22(5) of the Constitution of India. So it says that 22(1) that is arrest and 22(5) that is detention grounds should be same and similar in both the cases. That is what it came to the finding by giving the example of resication versus this judgment, Your Lordship, versus state of Maharashtra. I'm not reading that as of now. Lordship will then take up paragraph 29. That is at page 13. This is actually from resication. What I'm trying to point out has been stated here, Your Lordship. That's it. The language used in Article 22(1) and 22(5) of the Constitution of India regarding the communication of ground is exactly identical. So it should be the same. Neither of the constitutional provisions requires that the grounds of arrest or detention, as the case may be, must be communicated in writing. Thus, interpretation to this important facet of the fundamental right as the case by the constitutional bench while examining the scope of Article 22(5) of the Constitution of India would is perfect apply to Article 22(1) of the Constitution of India in so far the requirement to communicate the grounds of arrest is concerned. So it says that both should be exactly identical. Now, Lordship will kindly come to para 30. Hence, we have no hesitation in reiterating that the requirement to communicate the grounds of arrest or the grounds of detention in writing to a person arrested in connection with an offense or a person placed under preventive detention as provided under Article 21 and Article 22(1) and 22(5) of the Constitution is sacrosanct and cannot be breached at any situation. Non-compliance of this constitutional requirement and statutory mandate would lead to the custody and detention being rendered illegal as the case may be. Then your lordship will kindly take up para 38. That is page 15. The interpretation given by the learned single judge that the grounds of arrest were conveyed to the accused in writing by the arrest memo is unacceptable on the face of the record because the arrest memo does not indicate the grounds of arrest being incorporated in the said document. Column so and so being reproduced herein below simply sets out. Now this is important here. Sets out the reasons for arrest which are formal in nature and can be generally attributed to any person arrested on acquisition of an offense, whereas grounds of arrest would be personal in nature and specific to the person arrested. This is a very interesting part, Your Lordship. Why I'm saying I'll come to a judgment, very recent judgment, I think 10 days back it has come, where this has been discussed, Your Lordship. What is personal and what is the specific general? General means there is a case, a car has been stopped, so and so, you recovered some contrabands from them, you are found in that, the person has been found, so you are arrested under section so and so, so and so, so and so. This is a general view. And specific will be, it will be with regard, we have charged you and from your possession, we have found so and so contraband, and this is the contraband which is XYZ, whatever it is. Then, Your Lordship, it will be have to be personal. Then you are eligible, you have violated this provision, that provision. This is how it should be. I'll come to that later. So this is why I brought in paragraph 38. Lordship will now turn to para 46. That is at page 17 units. We are of the firm opinion that once this court has interpreted the provision of the statute in context to the constitutional scheme and has laid down the grounds of arrest have to be conveyed to the accused in writing expeditiously Here the word is used expeditiously. The said ratio becomes the law of the land, binding on all courts in the country by virtue of Article 141 of the Constitution. So this judgment has been rendered under Article 141, making it a ratio and law of the land. So whatever has been stated in this judgment have to be followed in future, Your Lordship.
This is paragraph 40,
Para 46,
43,
46,
6.
page 17.
Okay. Right.
46, court says that it is the binding, it is the law of the land binding on all courts in the country under Article 140. Now, Your Lordship, again I am coming to the point of arrest memo and the notice. Here again in para 48, Your Lordship will see, we have carefully perused the arrest memo and find that the same nowhere conveys the grounds on which the accused has been arrested. The arrest memo is simply a pro forma indicating the formal reasons for which the accused has been arrested. So normally what has happened, Your Lordship, they give an arrest memo and said, no, these are the same, so you are arrested, they have given you, these are the grounds of arrest. That is not the grounds of arrest. That is the reason for your arrest. The grounds of arrest is a different thing. It has to be personal to the person concerned who is arrested. Now, Your Lordship will come to para 49. Now, the difference has been specifically given here. It may be reiterated at the cost of repetition that there is a significant difference in the phrase reason for arrest and grounds of arrest. The reason for arrest as indicated in the arrest memo are purely formal parameters to prevent the accused person from committing any further offense or for proper investigation of the offense, to prevent the accused person from causing the evidence of the offense to disappear or tampering with such evidence in a manner to prevent the arrested person from making inducement, threat or promise, or to any person acquainted with the facts of the case, or so as to dissuade him from disclosing such facts to the court or to the investigating officer. These reasons would commonly apply to any person arrested on charge of a crime, whereas the grounds of arrest would be required to contain all such detail in hand of the investigating officer which necessitated the arrest of the accused. Simultaneously, the grounds of arrest informed in writing must convey to the arrested accused all basic facts on which he has been arrested so as to provide him an opportunity of defending himself against the custodial remand and to seek bail. Thus, the grounds of arrest would invariably be personal to the accused and cannot be equated to the reasons of arrest which are general in nature. So this is with regard to the judgment of Prabir Protest. Now I'll take Your Lordship to another judgment, that is judgment of Vihan Kumar versus State of Haryana. That is 2025 SEC Online 269. Here, Your Lordship, I'll take Your Lordship to para 14, 1-4. Many paragraphs are there, Your Lordship. What is it is basically the same thing has been explained again and again in different judgments. So I'm not going into that. I'm going to specific a few paragraphs which are a bit different from the others. Para 14 that Your Lordship will find at page 11 of the judgment. I'll just read it. Thus, the requirement, Your Lordship, for informing the person arrested of the ground of arrest is not a formality, but a mandatory constitutional requirement. Article 22 is included in Part 3 of the Constitution under the heading Fundamental Rights. Thus, it is the fundamental right of every person arrested and detained in custody to be informed of the grounds of arrest as soon as possible. If the grounds of arrest are not informed as soon as may be after the arrest, it would amount to a violation of the fundamental right of the arrestee guaranteed under Article 22(1). It will also amount to depriving the arrestee of his liberty. The reason is that, as provided in Article 21, no person can be deprived of his liberty except in accordance with the procedure established by law. The procedure established by law also includes what is provided in Article 22(1). Therefore, when a person is arrested without a warrant, and the grounds of arrest are not informed to him as soon as may be after the arrest, it will amount to violation of fundamental rights guaranteed under Article 21 as well. In a given case, if the mandate of Article 22 is not followed while arresting a person or after arresting a person, it will also violate fundamental right to liberty guaranteed under Article 21 and the arrest will be rendered illegal. On the failure to comply with the requirement of informing grounds of arrest as soon as may be after the arrest is vitiated. Once the arrest is held to be vitiated, the person arrested cannot remain in custody even for a second. Now, Your Lordship, I'll take one more paragraph, that is paragraph 16, 1(6). I'm not reading all these paragraphs, Your Lordship, because unnecessarily same has been repeated. So 16, the points that I'm making will be in these paragraphs. Para 16, same page, para 16, page 11, last paragraph. An attempt was made by the learned senior counsel appearing for the first respondent to argue that after his arrest, the appellant was repeatedly remanded to custody and now a charge sheet has been filed. His submission is that now the custody of the appellant is pursuant to the order taking cognizance passed on the charge sheet. Accepting such arguments will, with great respect to the learned senior counsel, will amount to completely nullifying Article 21 and 22(1) of the Constitution. Once it is held, the arrest is unconstitutional due to violation of Article 22(1). The arrest itself is vitiated. Therefore, continued custody of such person based on orders of remand is also vitiated. Filing a charge sheet and orders of cognizance will not validate an arrest which is per se unconstitutional, being violative of Article 21, 22 of the Constitution of India. We cannot tinker with the most important safeguard provided under Article 22. Now, para 19, Your Lordship. Here, they have stated with regard to section 50. An argument was sought to be canvassed that in view of the subsection 1 of section 50 of CRPC, there is an option to communicate to the person arrested full particulars of the offense for which he is arrested or on the grounds for the arrest. Section 50 cannot have an effect of diluting the requirement of section 22(1). It have so, section 50 will attract the vice of unconstitutionality. Section 50 lays down the requirement of communicating the full particulars of offense for which a person is arrested to him. The other grounds for such arrest referred to in section 51 have nothing to do with the grounds of arrest referred to in Article 22(1). The requirement of section 50 is in addition to the provided in Article 22(1). Section 47 of the BNSS is the corresponding provision. Therefore, what we have held about section 50 will also apply in section 57 of BNSS. So here, the corresponding section has also been taken up by the Honorable Supreme Court. Now, the conclusion which the court arrived, Your Lordship, that I'll read, that is in para 21. As conclusions heading it has been given in paragraph 21, Your Lordship. There are, I think, six conclusions derived by the court, and I'll read these conclusions, Your Lordship. Very specifically, it is given what to be done. 1. Therefore, we conclude, Your Lordship, para 21. A. The requirement of informing a person arrested on the grounds of arrest is a mandatory requirement under Article 22(1) that I have stated. B. The information of the grounds of arrest must be provided to the arrested person in such a manner that sufficient knowledge of the basic facts constituting the grounds is imparted and communicated to the arrested person effectively in the language which he understands. The mode and matter of communicating must be such that the object of the constitutional safeguard is achieved. This part, Your Lordship, what has happened in the case of 1962 Residency case, the person did not understand English, but he was communicated in English. Then that was the ground where it was, they said that he has been translated in Hindi and explained to him, but there was no proof about that. Therefore, he was granted bail in that case.
Well, that's under the requirement of NSA must be communicated in his own language.
Yes. So that is what has been given. See, Your Lordship, now. When arrested accused alleges non-compliance with the requirement of Article 21, the burden will always be on the investigating officer agency to prove compliance with the requirements of Article 21. So once I say that this has not been compliant, the government will have to give the proof whether that has been compliant. Burden goes to him. The non-compliance of Article 22(1) will be violation of the fundamental right of the accused granted by the guaranteed by the said article. Moreover, it will amount to violation of the right to personal liberty granted under Article 21 of the Constitution. Therefore, non-compliance with the requirement of Article 22(1) vitiates the arrest of the accused. Hence, further orders passed by a criminal court of remand are also vitiated. Now, they cannot say that we have so many further orders have been given, but that will not be an answer because everything will be vitiated. Needless to add that it will not vitiate the investigation, charge sheet and trial. So it will not vitiate the trial, including the charge sheet and the investigation. But at the same time, filing of charge sheet will not validate a breach of constitutional mandate under Article 20. When a person is arrested, person is produced before a judicial magistrate for remand, it is the duty of the magistrate to ascertain whether compliance of Article 22(1) and other mandatory safeguards have been made. And lastly, Your Lordship, when a violation of Article 22(1) is established, it is the duty of the court to forthwith order the release of the accused. That will be a ground to grant bail even if statutory restrictions on the grant of bail exist. This is a very important part. Whatever statutory restrictions are there, in a case of NDPS, the restrictions are under section 37 of the NDPS Act. That restrictions will not apply. The statutory restrictions do not affect the power of the court to grant bail when the violation of Article 21 and 22 of the Constitution is established. Now, Your Lordship, one more paragraph I'll refer in this case. Normally, nobody points out that. I'm pointing it out. This is in para 31. This is direction to all the high courts. What the high court should do. Para 31, page 16. I'll read. The learned single judge unfortunately has equated information given regarding the appellant's arrest with grounds of arrest. The observation that the allegation of non-supply of the grounds of arrest made by the appellant is a bald allegation is completely uncalled for. All courts, including High Court, have a duty to uphold the fundamental rights. Once a violation of a fundamental right under Article 22(1), as was alleged, it was the duty of the High Court to go into the said contention and decide one way or the other. When a violation of Article 22(1) is alleged with respect to grounds of arrest, there can be possible two contentions raised: that the arrested person was not informed of the grounds of arrest, or purported information of grounds of arrest does not contain any grounds of arrest. As far as the first contention is concerned, the person who is arrested can discharge his burden by simply alleging that grounds of arrest were not informed to him. If such an allegation is made in the pleadings, the entire burden is on the arresting agency or the state to satisfy the court that effective compliance was made with the requirement of Article 22(1). So here, Your Lordship, we have specifically stated that it has not been complied with. We have not been given the grounds of arrest at all. Now they have to show, but in their objection, they have not stated anything in this. In the second part of the same judgment, Your Lordship, this is by Justice Koteshwar Singh. It was next page, Your Lordship, page 17. The same judgment, Your Lordship, another. I'm not going to read the whole part. I'm just pointing one thing from this judgment. Here, the learned Justice Koteshwar Singh has went one step forward by saying that not only 50A will have also to be complied with. That means information with regard to the arrest have to be given. These grounds of arrest will have to be given to his friend or relatives, so that since the person would be in custody, he will not be in a position to get an advocate or a counsel to defend him. Therefore, it is mandatory that that should be informed to the his relatives or friends, so that they can gather an counsel for granting his bail, for getting bail for him. This is basically, I'm not reading this part in paragraph 2 and 3. The court has detailed and said that if that is not followed, even then it is violation of constitutional provisions of Article 21 and 22. Now, Your Lordship will go to the next case, that is Kachi Reddy Upender Reddy. This is the latest judgment, I don't know whether that is reported somewhere or the other. This has come up, I think, then a few days back, maybe 10 days back. It was on 23rd of May, Your Lordship. Judgment was delivered. So I do not have any citation for this, Your Lordship. This is a judgment in the case of Kasireddy Upendra Reddy, Your Lordship. Here I am relying on paragraph 14, 15, 18, 36. So Lordship will kindly turn up 14, 1-4.
Paragraph 14.
1-4. Then 15
and
18. Then Your Lordship 36. So first I'll read para 14, Your Lordship. Here, Your Lordship, I am reading para 14 for benefit of Your Lordship to the fact that how a ground of arrest should be given, Your Lordship. Here the court has quoted the ground of arrest given in this case, Your Lordship. That is why I am giving it, Your Lordship. Para 14, page 70. We shall now look into the grounds of arrest which were provided to the appellant's son in writing at the time of his arrest, and also the appellant as the father of the person arrested. The same read thus. Now Lordship will see. Grounds of arrest in respect of Sri Kasireddy Raja Sekhar Reddy so-and-so case number. This is the format, Your Lordship, how it should be provided. That is why I am taking up para 14. Here, Your Lordship, in the first part of that, the case of conspiracy, cheating, criminal breach of trust, so-and-so, it is the general reasons given here. Then Your Lordship will see down below, grounds of arrest, heading. Your Lordship, I'll just read 1 or 2 grounds of arrest, will know that it is personal to that person concerned. What it has been written, Your Lordship. Investigation done so far reveals prima facie case of conspiracy, cheating, criminal breach of trust and corruption. 1. You, what is used now, Your Lordship? You are the key person in organizing the kickback-driven liquor trade in AP, so-and-so, along with so-and-so, 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 and others has conspiracy, suppress popular brands, promote so-and-so, and cause wrongful gain about so-and-so crores towards kickback in liquor syndicate through public servants by corrupt practices. 2. In pursuance of the conspiracy, you have controlled issuance of OFS to suppliers based on kickback received. You used to get sales data, calculate the kickback amount, and used to collect kickbacks through Bunetti, so-and-so. Third, you have threatened SPY Agro Agency and took over the control of SPI and managed the accounts without their consent. You are further responsible for transfer of money of so-and-so, so-and-so. Then you are responsible for floating so-and-so. This is the way, Your Lordship, normally a ground of arrest have to be given. This is the format, Your Lordship, how it's to be. This is why I have read that, Your Lordship. Then Your Lordship will kindly take up 15, para 15. Now it says in para 15, the path-breaking judgment of this court in the case of Vihan Kumar. So Vihan Kumar, this court now says that it is a path-breaking judgment. Serves as a pivotal reference point in Indian jurisprudence regarding the rights of individuals upon arrest. The judgment of Vihan Kumar has profound implications for enforcement of Article 22 of the Constitution across the country. It underscores the judiciary's commitment to uphold the constitutional protections against arbitrary arrest and detention. This decision sets a clear precedent, and the investigating agency, police officer, authority effecting arrest of any person in connection with any cognizable offense without a warrant must provide specific actionable reasons for an individual's arrest beyond citing broad provisions of law. It has to be specific actionable reasons beyond the general provisions. A clear dictum has been laid in Vihan Kumar Supra that the law enforcement agencies must exercise greater diligence in communicating the precise grounds of arrest in order to avoid unlawful detention. The decision further reinforces the right to legal recourse through habeas corpus petitions, empowering individuals to challenge the legality of the detention effectively. 16. In Vihan Kumar, this court, I'm 16 I have not given because it has quoted Vihan Kumar. I'm not again reading Vihan Kumar again. I have already read that. So I'll not read Bihan Kumar. Straight away, your lordship, I have stated para 18. Para 18, your lordship, again, what has the court in this court? Thus the following principles of law could be said to have been laid down rather very well explained in Bihan Kumar. So what it has been, it has given your lordship. In fact, it has quoted the conclusions that I have already said in para 21 on Bihar Kumar. That has been quoted. So I'm not reading that again. Now your lordship will kindly go to paragraph 36. If a person is arrested on a warrant, the grounds of arrest, ground for reasons for his arrest is the warrant itself. If the warrant is read over to him, and that is a sufficient compliance with the requirement, and that he should be informed of the ground of arrest. If he is arrested without a warrant, in this case, he must be told why he has been arrested. If he is arrested for committing an offense, he must be told that he has committed a certain offense for which he would be placed on trial. In order to inform him that he has committed a certain offense, he must be told of the acts done by him which amounts to an offense. He must be informed of the precise acts done by him for which he would be tried. Informing him merely of the law applicable to such act would not be enough. See Bimal Kumar Mehra. This is Bimal Kumar Mehra is actually a judgment of the Honorable Allahabad High Court. I'm not placing that since the court has already quoted what is required to be given in the grounds of arrest. I'm not going into that here. Now your lordship will kindly take up. These are basically the judgments which I am relying with regard to non-supplying of the grounds of arrest to the petition. In the petition itself, we have annexed the document, grounds of arrest under section 50. The court says that it has to be specific to the person, that it should be personal to the person concerned. And therefore, your lordship, basically, general information given to him will not be ground of arrest, like the name, addresses and all, and the sections quoted, and he is informed about the trial. This is not it, your lordship. It has to be specific. And in the case, this case, your lordship, Remirity, the court has specifically, there is a paragraph which says how the grounds of arrest have been given. It should be similar to that, specific and personal to the person concerned. That is the basic, my argument with regard to non-supply of grounds of arrest, your lordship. The rest of the judgments, your lordship, are also on the same, but these are the judgments which overall takes into consideration my argument that the grounds of arrest have not been provided. So I'll not go into some other judgment. If my learned friends submit something and I am required to reply, then I may go into that.
Yeah, please. See, the basic argument of the petitioner is that ground of arrest was not supplied to. Lordship, before that, lordship has to note down some dates. The petitioner was arrested on 18/12/2022. And he was served memorandum of arrest on that day, along with notice under section 52 CRPC. Now, lordship, I am relying on one judgment of the, probably my learned friend has missed out one important judgment with regard to service of ground of arrest. This is for Pankaj Bansal and Union of India, reported in 2024, 7 SCC 576. From that judgment, lordship, this law was developed. Lordship, before that, I want to place section 20, article 22(1) of Constitution. Merit laws. Protection against arrest and detention in certain cases. 1. No person who is arrested shall be detained in custody without being informed as soon as may be. So the dictation of Article 22(1) is he is to be informed about his detention without being shall be detained in custody without being informed. Lakshmi, please to note down the words used in Article 22. Without being informed.
And it is admitted that Lordship he was informed by memorandum of arrest as well as by notice under section 57. Lordship.
Once the Supreme Court has interpreted, given the
Yes,
direction,
Lordship, I am coming to that. Lordship, that law has been developed.
how this could be a meaningless exercise.
From Pankaj Bansal and others also. It was reported in 24/7 SCC and the judgment was pronounced on 3/10/2023, Lords. And I'm placing one judgment of coordinate bench that has been explained in that judgment also, Lords. Paragraph 24. That judgment was not placed before consideration of your Lordship. Paragraph 24. It would be worthwhile to mention that the apex court has held in the case of Pankaj Bansal, Union of India, which is reported in 24/7 SCC 576, that ground of arrest must be communicated in writing to the accused. However, the case of Pankaj Bansal can be made applicable only to arrest made after the said detention rendered by apex court on 3/10/2023. In other words, in respect of the arrest made after 3/10/23, an arrestee must only be made known the ground of arrest, but the same must also be communicated in writing. Then let's say paragraph 27. Paragraph 27. In the present case, the accused petitioner was arrested on 27/2023, and therefore the decision of the apex court in case of Pankaj Bansal is not applicable. Hence, the arrest of the accused person cannot be said to be held illegal. Viewed thus, I am of the unhesitant view that the facts of the present case, Article 22(1) of the Constitution of India has been sufficiently complied with. That being so, no violation of Article 21 is made out in the instant case. Lordship, this is arrest memo. And my learned friend has annexed section notice under section 50 along with this is application. So that is at page 24. Same date. Then Lordship may come to section 50 CRPC.
Yes.
Section 50. Person arrested be informed of ground of arrest and of right of bail. Every police officer or other person arresting a person without warrant shall forthwith communicate to him the full particulars of the offence for which he is arrested or other grounds of such arrest. Now Lordship may come to page 24 of the bail application. Whether all these information are contained in this notice or not. Full particulars of offence for which he is arrested. Let's see page 24. Then let's see in the first part, all details has been given. Then case number is given under which section he has been arrested. You are hereby informed that you are arrested in connection with the above referred case and case is non-bailable. So you are forwarded to the court. You may submit petition before the court for your bail. Then below he put his signature. So in my humble submission, Lordship, all compliance of particular section 50 as well Article 21 has been complied in. And Lordship, furthermore, the law, the Supreme Court has explained that the ground of arrest should be communicated to him in writing. That is from Pankaj Bansal. That was pronounced in 3/10/2023, and he was arrested. In the present case, the petitioner was arrested on 18/12/2024. As
No, but when subsequently, if it has been interpreted by the Supreme Court and Article 141 applied.
Lord, that is correct, Lordship. But Lordship, the prospective and restorative effect application of a judgment, unless it is stated in the judgment, all judgments are relied on prospectively, Lord.
No.
Yes, but you will get
No,
your
no.
permission. And Lordship, our High Court has explained this. Lordship, I submitted the judgment also, Lord. That was pronounced in the month of May 2025, Lord. In paragraph 24 and 27, I have read out, Lord. Unless, Lordship, as I know, unless the judgment is it is explained in the judgment, whether it will be prospective or retrospective, all judgments will be applicable prospectively. So we due respect to all the judgment pronounced by the Supreme Court, Lordship, all these are not applicable in the present case, Lord. And furthermore, Lordship, the arrest memo as well as section notice, Lordship, all information has been provided to the petitioner. And his family member was also informed by our telephone, Lordship. That is also written in the arrest memo, Lord. And subsequently, our High Court in different judgments has explained this. Recently, with respect to compliance of section 48 of BNSS, this Honorable Court says that if he was informed our telephone by as per the information provided by the accused person, there is sufficient compliance of section 48 of BNSS laws. These are the few judgment, Lordship, on this point by different coordinate benches of our High Court regarding compliance of section 50, ground of arrest, and all these things are there, Lordship. In substance, Lordship, since the petitioner was arrested in 2022 and Pankaj, the law was explained after 3/10/2022, 23. In Lordship, in my submission, all these judgments are not applicable in the present case.
Share these cases case numbers to Mr. Manan also.
I'll submit. I'll supply. Bail application 1100. What actually? And is it admitted, Lordship, he was arrested on 18/12/2022? Much before Pankaj Bansal's case, Lordship. Not to speak of Pihan and Parveer Tugas, that was recent judgment. This is humble submission, Lordship, in the case, the petitioner is not entitled to benefit of bail for violation of so-called Article 22(1). In my humble submission, Lordship, section Article 22(1) as well as 50 was fully complied with, and this is all these judgments of Honorable Supreme Court. These are the subsequent judgment, and the petitioner was arrested earlier, so all these judgments are not applicable in the present case. This is my humble submission.
So what my learned friend has tried to say is that the judgments of the Honorable Supreme Court will not be applicable because the petitioner was arrested prior to Pankaj Bansal's case. In fact, Your Lordship, I've already given one judgment. I was not referring to that because I don't know that he will raise this issue. My learned friend says that all the judgments will be prospective in effect until and unless something is to be given in the judgment itself, which will show it to be retrospective. So Your Lordship will kindly take up the set of judgments we have given. In that, there is a judgment called Kanishk Sinha versus the state of West Bengal. This is judgment of the Honorable Supreme Court, which was delivered on 27th of February 2025. Kanishk Sinha versus state of West Bengal. If it is not there, I'll give a copy, your lordship, for going into this. I think I have given that.
No, connection is not here.
I have not given, then I'll give this copy itself, or I'll give a photocopy and give it to you. Just one point that which my learned friend said, which has been clarified. This is judgment of the Honorable Supreme Court. In this judgment, your lordship, at para in para 3, your lordship, para 3, I'll just name of the Kanishk Sinha, Kanishk, Kanik Sinha versus and another versus the state of West Bengal. Here I am relying on para 3, your lordship. I'll just read that operative part. I'll hand over yours. Now the law of what court said, same thing was the issue there. So what it states. Now the law of prospective and retrospective operation is absolutely clear. Whereas a law made by legislature is always prospective in nature unless it has been specifically stated in the statute itself about the retrospective operation. The reverse is true for the law which is laid down by a constitutional court or as it is interpreted by a court. The judgment of a court will always be retrospective in nature unless the judgment itself specifically states that the judgment will operate prospectively. So what my learned friend said, exactly the opposite. When a court delivers a judgment, it is always retrospective until and unless the court says that it has to be prospective. So that is what I am trying to point out. Therefore, let us forget Pankaj Bansal. I can also refer Pankaj Bansal. Pankaj Bansal upheld Article 22(1). I did not because same thing has been repeated. Even Pankaj Bansal was considered in the case of Vihan Kumar. So I'm not reading Vihan Kumar. In fact, that particular paragraphs have been quoted in Vihan Kumar also. I'm not going into all these things, but I'm trying to point out that it has now what Pravi Prakash said. It has to be the law of the land. Once it has been directed to be the law of land, it cannot be prospective. It is a retrospective, your lordship. And in fact, let us forget that Madhu Limai, 1969, that's the judgment I have given. That also uphold Article 22(1) for non-submitting the grounds of arrest. Where is the question, your lordship, that these are retrospective? And some other judgment must have been in between. I am not bringing all those judgments anyway. But this is a specific case where this honorable court, in this case, has specifically stated what is prospective, what will be retrospective, and it has been stated that the constitutional bench or constitutional court judgment will always be a retrospective judgment. Therefore, what my learned friend said is actually opposite to what the law is in. Basically that. So I'm giving a copy of that. And in fact, one more thing I would like to point out in this case. With regard to and in fact, there were so many a few judgments placed by my learned friend, which are of the coordinate benches. In fact, I have appeared in many cases of the coordinate bench, basically in all the courts. And in all these courts, your lordship, there are various judgments which went in favor of granting bail to the accused. So I'm not placing a single judgment because there are some judgments which went against, some judgment went in favor of the accused person, considering that particular facts and circumstances of the specific case. Since I am already relying on the Honorable Supreme Court judgments, therefore I have not placed any such judgments here. In the case of Pankaj Bansal, I'll give a copy of that because my learned friend was relying. I in fact bought that. I thought. I can give you. In fact, in the case of Pankaj Bansal, you see, Madhu Limai was considered the old case. That is at para 17 of Pankaj Bansal. Pankaj Bansal is your lordship. I have given a copy of that. Since my learned friend was not relying to that, anyway, he said that after Pankaj Bansal it has come. That is why I'm just pointing it out. This is 2024 7 SCC 576. In para 17 of the judgment, it quotes your lordship Pankaj Madhu Limai. Then your lordship, para 29 of that. I'm just making two paragraphs. 29 of that. It provides that para 20, para 17 I'm not reading because it has quoted Modulima. So I'm not going into that. Para 29, that is at what it said, Your Lordship, in this regard, we may note that Article 22(1) of the Constitution provides inter alia that no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds of such arrest. This being the fundamental right guaranteed to the arrested person, the mode of conveying information to the ground of arrest must necessarily be meaningful so as to serve the intended purpose. So again, so many things. It may be noted that Section 45 of so enables person arrested under Section 19 to seek release on bail, but it postulates that unless the twin conditions prescribed hereunder are satisfied, such a person would not be entitled to gain. The twin conditions set out in the provisions are that firstly, the court must be satisfied after giving an opportunity to the public prosecutor to oppose the application for release, that there are reasonable grounds to believe that the arrested person is not guilty of the offense, and secondly, it is not likely to commit an offense while on bail. To meet this requirement, it would be essential for the arrested person to be aware of the grounds on which the authorized officer arrested him under Section 19 and the basis of the officer's reason to believe that he is guilty of an offense punishable under the Act. It is only if the arrested person has knowledge of these facts that she would be in a position to plead and prove before the special court that these are the grounds to be believed that he is not guilty of such offense so as to avail the relief of bail. Therefore, communicating of the grounds of arrest as mandated by Article 22(1) of the Constitution of India and Section 19 of the Act is meant to serve the higher purpose and must be given due importance. This is the reason, Your Lordship, I did not go into Pankaj Bansal and decided on that. Here, Your Lordship, it says that it should be given in writing. It says that it should be henceforth, it should be given in writing. Therefore, they say that since the word henceforth has been used, so they say that yes, prior to that, you need not, the arrestee person need not be given the grounds of arrest at all. That is not the law, Your Lordship. Law is laid down in Madhulimaya itself. Therefore, it has gone through till date. And the mainly, Your Lordship, under Section 151, Pukasta made it the law of the land.
Where is the observation of henceforth?
Henceforth, Your Lordship will get at page para 35.
35.
Para 35. On the above analysis, to give a true meaning and purpose to the constitutional and statutory mandate of Article 19(1) of the Act of informing the arrested person of the grounds of arrest, we hold that it would be necessary henceforth that a copy of such written grounds of arrest is furnished to the arrested person as a matter of course and without exception. The decision of Delhi High Court in so and so, which hold to the contrary, do not lay down the correct law. And the case in hand, the admitted position is that the ED investigation merely read out or permitted reading of the grounds of arrest to the appellants and left it at that, which is also disputed by the appellants. As this form of communication is not found to be adequate to fulfill compliance with the mandate of Article 21(1) of the Constitution and 19(1) of the Act, we have no hesitation in holding that the arrest was not in keeping with the provisions of Section 19(1) of the Act. Further, as already quoted supra, the clandestine conduct of ED is proceeding against the appellants by recording second ECR immediately after the secures intervention and so does not command acceptance. It says risks of arbitrary excess of, in effect, the arrest of the appellants, and in consequence, their remand to the custody of ED and thereafter to judicial custody cannot be sustained. So what it said was that it has to be given in writing. Earlier, Your Lordship, the judgment did not say whether in writing or not. Normally, it has been given in writing, but it has not been specified whether it should be given in writing or not. Then this came, it says that it has to be given in writing. Then Prabhu Pukasta came and he laid down the law, said that no, it has to be in writing. And in fact, in Bihan Kumar, this particular paragraph has also been quoted in Bihan Kumar, where it says that though it has been stated this way, but communication should be there. It should be a communication. And if there is a communication by Your Lordship without writing, then it will be difficult to prove. Therefore, that has to be incorporated in the law. And secondly, Your Lordship, one more judgment that I'll refer, that is the judgment of, here only one paragraph I'll refer. This is the, that I given or not, I don't know. Union Territory of Ladakh versus Jammu and Kashmir, National Conference. I'll give these two. I'll just read one paragraph. Oh, sorry, I have it. Sorry, I have both. Comics and also the comment. Edit on. Kanisk, I have given the copy, I have got that. For the Union Territory of Ladakh versus Jammu and Kashmir National Conference. This is 2023 SCC Online SC 1140. Here only one paragraph I will rely on, paragraph 35. Paragraph 35 is at page 17. Again, the pages are given on the right hand side below. Page 17, paragraph 35. We are seeing before us judgments and orders by high courts not deciding cases on the grounds that are leading judgment of this court on the subject is either referred to larger bench or review petition relating to thereto pending. We have also come across examples of high courts refusing deference to judgments of this court on the score that a later coordinate bench has doubted its correctness. In this regard, we lay down the position of law. We make it absolutely clear that the High Court will proceed to decide matters on the basis of the law as it stands. It is not open unless specifically directed by this court to await outcome of reference or review petition as the case may be. It is not open to a High Court to refuse or to follow a judgment by stating that it has been doubted by the later coordinate bench. In any case, when faced with conflicting judgment by benches of equal strength of this court, it is earlier one which is to be followed by the High Court as held by Stranger Street. Now here your lordship specific. The law as has been laid down today in the case of Pravir Purkayastha is the law of the land and it has to be followed. As of today, until and unless there is a reference or some other comes that if the law is changed, then it will change. As of now, that is the law. That is what I am trying to. And the other case that I have given with regard to Kanisk that Kanisk case I have already made paragraph 3 where your lordship will find paragraph 3 plus
That I noted.
that paragraph 3, that part with regard to prospective and retrospective that I have given.
With respect to respecting prospect, recently Supreme Court has pronounced a judgment today I have not brought. But civil law I can submit to tomorrow.
Well, morning at 10:30. Before 10:30, give it to the court master and give the citation to Mr.
Yes, sir.
Pradhan.
And let's see further, the recent judgment cited by my learned friend is not applicable in this case in the present facts and circumstances of the case. Because that is with respect to if there is a conflict between the judgment of the Supreme Court, which judgment is to be taken into consideration. Here lordship case is very clear. He was arrested in 22. So the law prevailing at the relevant time was to be considered. Anyway.
The submissions of Mr. Vyas Sandan and counsel for the petitioner, as well as Mr. S. C. Kyal and standing counsel for the NCBs concluded. Mr. Howard, the standing counsel for the NCB, waits for some time to provide a copy of citation which has not been addressed today. Stop prayer is allowed. The copy of citation may be provided to the court master at 10:30 AM on 10/6/2025. Next one, list. Give it on Monday for others. On 16/6/20 for delivery of orders.
Much.
Nice office.